righty ho, chickadees. It's Wine and Crime Saturday because, unfortunately, I got myself a little cold earlier this week and I was not up to par by any stretch of the imagination. And I needed to have a nice long date with my bed, my favorite jammies, and my pillow. And I did. I rested a lot, but I feel much, much better now. My apologies for having to reschedule this particular live stream. I've been very much looking forward to doing this live stream because we are going to catch up. What are we going to catch up on? Everything. Everything. We're going to catch up on all of it. There are, I want to say, about 5 hearings that we're going to get an update on this evening. I will give you the choice on whether you would like to watch the Antonio Brown hearing or if you would like me to read the decision in reference to Mandy Matney. Yes, our friend, Little Miss Vocal Fry, Mandy Matney. We will decide that later on in the live stream. Oh gosh, I'm all tangled up in everything. But for now, make sure you tell me what you're drinking because it's a Saturday night. So we can have Wine and Crime Wednesday on Saturday night. And I am definitely having my Moscato. This is my special, I don't know what you call these, thermos. It says Hakuna Moscato. It means drink wine. And I shall be drinking it. Now, I do have my backup water because you just can never be too hydrated these days, you know. So I am Moscato bound tonight. I felt like I needed it. It's a Saturday night. I finally feel a whole lot better today than I had earlier this week. Woo! It was a rough week, up and down and up and down. Oh my goodness. All righty, yes. Kelly, our marvelous mod, is with us again this evening. Thank you so much. I know this is unusual. Saturday nights are difficult. People have other things that they need and want to do other than hang out with me. But for all of you that do decide to hang out with me or you decide to watch on replay, thank you so much. I do very much appreciate all of you spending your time with me. Time is one of the most precious things we possess, and I do very much appreciate when you make the choice to be here with me. On to Hey Debbie. Debbie's back with us this evening, and we have Camper for Life. Peppermint PJ. Hey, glad to have you. Also, if you're watching on the Twix, thank you so much. Love the fact that you're watching, whether it's on the tubes of you or the Twix. Make sure if you haven't subscribed, you do that. Also, if you haven't become a member, you might want to. I am going to be spending some time in the next few weeks getting some members only things teed up for us. I'm going to do some updates on my intro. I am going to likely change some of our emojis. It's time for a little refresh. And once my life is a little more stabilized, and when I say stabilized, I mean a little less on my plate, I'll be able to spend some time to get those things done. So I'm happy to report that Mr. Demeanor, I haven't caught up on everything either, I should say also. Mr. Demeanor and I took a long drive today. He needed to take care of some work and I went along with him. And so we spent the day together and I really wasn't on social media at all. I try very hard on the weekends to be present with the people in my life. I hope you all do the same. It is very important that you do that. And so I have not spent a lot of time on social media. I absolutely need to get caught up on all of the updates that Lauren Conlon has been putting out there in the David Anthony Burke case. I'm very interested in that. But something I did get to this week when I wasn't feeling so great, I watched the Tyler Robinson hearing. Y'all. I was not going to follow this case because I was concerned it would be politically charged, and y'all know I don't do any of that crazy drama. But I think I'm going to have to follow this case now. There is a lot that came out in those hearings of hard evidence, and my interest is piqued now. So very happy to say that, yes, I will be following that. I know everybody's talking about Linda Clancy. I'm out. Tapping out on that one. Can't do it. You know, it's kids. It's an important case. I do not deny that. My soul cannot handle that case for anybody involved. So I will be getting some summaries and some updates from afar, but I will not be covering it on my channel. Hey, Mrs. Georgia Mom. Happy Saturday to you too. Glad you could join us. And what I was getting ready to say was that Mr. Demeanor and I were out on a drive earlier today. We came back home, and of course, he checked on his guppies. He's had a rash of deaths, which he thinks is likely disease related. And so it's been very traumatic. And he had this beautiful, very, very pregnant guppy. It was a special one that was shipped to him. And that was the last one in that particular group of 10 that he got. And it passed away yesterday. He found it in the tank yesterday. And literally right before I went live, he knocks on the studio door here and he's like, "Are you already on?" I'm like, no, I'm good. And he's like, "I found 2 teeny tiny little babies from that very pregnant one that I had." So she must have died during, while she was giving birth. And so he did at least get a couple. Hey, Flumtork. Glad you could pop in. Hope you had a great day. Tell me what you're drinking. I got my Hakuna Moscato. Alrighty, so first on the docket for this evening, we're going to go to the hearing for Sarah Grace Patrick. Sarah Grace Patrick, if you all remember, is being accused of taking her mother and her stepfather's life. She was all over the TikTok. Y'all know what I'm talking about. She said and some weird things at the funeral, and she behaved oddly. And well, anyway, she's in custody. And this was the most recent hearing. So I'm going to get us all queued up here. And I have not watched any of this ahead of time. So we'll be doing this all on our own for the first time. Maybe some of you have seen some of them. Please, no spoilers if you have. But we're going to go ahead and get started with Sarah Grace Patrick's hearing first.
And for the record, my name is Sean Hoover. I have recently joined, or I am the attorney for Ms. Patrick moving forward. Latoya Williams was the attorney. She no longer works with the Public Defender's Office, so I will be moving forward here on.
Now, now that you paused, you said recently, you opened this case in February.
February, that's correct. For me, it's recent. I apologize. There's been a number of trials since then now. So I've been on the case since February, Your Honor, and we're asking for a continuance today regarding Ms. Patrick's case. I know the court has already read the case law involved. Just to put a couple of highlights on the record. For starters, Your Honor, once I took over the case, I put an entirely new team on Ms. Patrick's case. With that said, I got the case, there was a lot of discovery involved, started to go through the discovery while I was trying other cases. Once I realized there were certain issues that hadn't been addressed when Ms. Williams took represented Ms. Patrick, I started to
He's easy on the eyes, Debbie.
Bring a team in that could address those particular issues. At the beginning, I thought it was just a chain of custody issue, and it turned into a lot more than that. To give you an idea or a little more of an understanding, I brought in Mary Dayton, who is an attorney with the Public Defender Office. I worked with her when I was with the Capitol Office. She does a lot, has done a lot with juvenile clients, especially juvenile clients dealing with capital cases and dealing with forensics. What I thought was just a chain of custody issue turned out to be a much larger issue dealing with GBI, the Sheriff's Office, Police Department, and it's just evidence in general. With that said, we brought in also a mitigation investigator, Olivia, who's at the table with us as well, who also deals with capital cases, also deals with juvenile cases, but also deals with the mitigation aspects of it. Once Ms. Dayton and Olivia came in, we found out that based off of current case law, not only with the United States, but also in Georgia, certain issues weren't addressed when Ms. Williams had the case.
So I just want to remind you all, in case you've forgotten, what he's referencing with the mitigation for this case is much like we talked about and heard about in Zach Adams' case. There is a mitigation attorney that would be in charge of all of the mitigating factors that may come into the case if Sarah Grace Patrick is found guilty, and then they are trying to mitigate I'm assuming this is a death penalty case, or I can't imagine they'd have mitigation for anything else, but it's possible, I suppose, if it's just life without parole case. That's what he's referencing, is that is one attorney, and he has a different team put together. So I just was giving some reference for all of you.
Ms. Williams announced record, mainly because of the age of Ms. Patrick when the shootings actually occurred. Because Ms. Patrick was a juvenile at the time, case law is a little different when it comes to, for one example, sentencing in regards to how and when a juvenile can be sentenced to life without possibility of parole, death penalty, or life with possibility of parole. Because of those issues, I believe it was about 2 weeks ago, I believe Olivia just said that we got the defects information around June 30th, which literally wasn't that long ago. Yes, Ms. Williams had an expert that, to be nice, did some work on the case, but the expert didn't have Ms. Patrick's, and the expert I'm talking about, Dr. Schaefer, didn't have Ms. Patrick's defects records when he did his evaluation, when he spoke to Ms. Patrick and family members, when he came to his ultimate conclusion. Now that we have the defects records, that has opened up, lack of a better term, a whole other can of worms in regards to not only sentencing because of Ms. Patrick's age, but also our theory moving forward, especially crossing certain officers and certain witnesses based off of the evidence that we did receive from the state. So with that said, we're asking for a continuance for multiple reasons. The first one will be because now that we actually have a team in place that can actually address the issues facing Ms. Patrick because of her age at the time of the shooting, and because of all of the background history that Ms. Williams, she just didn't know about because she didn't have it. Literally, we sent you the order and you got the information to us as quickly as possible. But we're talking about over 10 years worth of information that now we have to go through, not only for sentencing, but to combat certain things that I believe witnesses and especially officers are going to say on the stand in regards to their investigation.
Hold it. Is he saying that Miss Williams didn't know that she was what she was being charged with? Sir, I'm already confused. Is he saying that Miss Williams didn't know her age? I don't know what is happening right now. PD, Mrs. G, Georgia Mom, another... Oh, this is a public defender. Yes. If that's what your question is. This is a public defender for her. Look, she looks a little too smug for me. She looks too smug.
So we're asking for a continuance for that reason, because we just need more time to go through all of that. again, the case law, like, I know the court's aware of the case law. The case law, not specifically, the case law points towards it's a sentencing issue, which it is, and we need more time for that. However, without going into more detail, there were certain statements made and certain reports that were written from the lead investigator and other officers, which tells me now that those defects records, the mitigation aspect of this case that we thought was something that we had, that wasn't as important during the trial, well, now it is. Because based off of what we've read and based off of what we received, it will be an issue in this case, especially with the lead investigator. So the first point we're asking for a continuance is because we now have the team put in place to address the issues specifically based on the mitigation aspect of this case, which was not addressed before. Dr. Shakur had an evaluation that the state has and the court has, but he did not have the information that we have. And based off of that information, more needs to be done so that I can adequately protect Ms. Patrick's interests moving forward. Furthermore, we're asking for a continuance, Your Honor, based off of evidence that we believe is still outstanding. And when I say that, again, when Ms. Williams had the case, the state Ms. Williams announced ready for trial. And I understand, based off of the information that the parties had at that time, they believed they were ready. However, once I took over the case again, I thought this was just a chain of custody issue, and it turned into something a lot bigger. And to give the court an idea without going into too much detail about our theory, since I've taken over the case, I've actually been able to delve or dive deep into it. There are issues with what officers did in this case. There are issues with the Georgia Bureau of Investigations in this case, and we have started to get more information, more evidence from the Georgia Bureau of Investigations and from law enforcement. With that said, the state and I met on Friday in person to go over the physical evidence in the case, and we talked about that as well, and the state is helping us get more information. And to be clear, this is not an issue that, like, the DA was hiding information. This was more of, I saw an issue that I believe Ms. Williams just didn't see, and it snowballed into something a lot bigger than just a
This is a lot of
issue.
words.
So now we are still trying to get information from Georgia Bureau of Investigation to fully understand the forensics in this case, to fully understand the chain of custody issue in this case, to fully understand.
Y'all, we have talked about chain of custody, we have talked about discovery, and now we're talking about forensics? Sir, tell us in a succinct fashion what in the bloody miserable HE double hockey sticks is going on in your case. Get it together, sir.
Understand the procedures in this case, and we are literally still requesting information from GDI that's still coming in, and now we've actually asked the DA to help us out on that because this is information they need as well. So this isn't something that's like, well, aha, we knew about this earlier. This literally, again, started out as a chain of custody issue, and it has snowballed into something bigger to where we're going, and this deals with possible 702 data issues moving forward. We're literally dealing with forensic evidence. We're literally dealing with chain of custody issues, proper procedure issues, not only through local law enforcement, but through the Georgia Bureau of Investigation. So we're asking for a continuance on that as well because there's still information coming in. And finally, Your Honor, and again, this is not me saying,
I have a problem because he just said that the DA's office is also in the same position. But nobody has an advantage then. You're both in the dark. This is how crap happens. Sir, have you paid attention to the Zach Adams case at all? Just curious.
the state withheld anything because I honestly believe the state didn't know about this as well. But on Friday, when I met with the state to go over the physical evidence, they sent a supplemental report from an officer with local law enforcement. The issue is this officer is in other reports. This officer is on the witness list, But from the information we received, the information Ms. Williams had, this officer literally didn't really do anything in the report. He was just there. Now we find out that this officer did not write a report. However, he went to the DA's office literally last week and said, you know what? Well, and I'm sure they can correct me if I'm wrong. My understanding, this officer had a hunch that the gun that was possibly used for the shooting was pawned by a certain person we never knew the name of from the discovery sent over by the DA. And that officer's hunch it went to another person that had the gun, and the officer tested the gun and then gave it back to the other person. We had no idea that these two people existed. We had no idea this test existed. We had no idea there was a possible another gun. We had no idea there was a possible hunch. We have no idea how the officer came to that conclusion. And again, Ms. Williams and the state announced ready for trial for January. The state didn't even know about this.
Y'all. I have issues. What is happening? Sir, you have made it around the globe about 4 or 5 times so far in this rambling motion for continuance. Somebody says somebody has something, then they tested it, and somebody else had it too. What? I feel like I'm in Massachusetts, y'all. Yes, Debbie, we are getting a good look at how he'll be in trial. Oh, Lord, help us. Let's imagine this opening statement. Woo, doggy. All right.
We are now in a position to where I honestly don't know. Was this one road officer that just did literally whatever he wanted to and never reported to anyone else? Or is there more involved in this? I need to now follow up on the hunches. I need to now follow up on how he even got to this conclusion. I need to now follow up on the 2 people, well, it is more than 2 people at this point that I didn't know about until Friday, literally Friday afternoon, that I need to now
it's called an investigation.
Find them, follow up on them. I need to go to the pawn shop to see what happened there. I mean, there's so much more information.
Chop, chop, dude. You got a whole team. Get it together.
Since I've taken over the case and I brought my team on, that we can't fully be prepared to go forward with defending Ms. Patrick. As of right now, and again, this
with
is
a
not
January
the DA's
trial
office
date?
that helped.
Did he not say just a moment ago a January trial date? Sir, you suck at your job. If you cannot be prepared for a January trial date, come on. That's a long time from now.
Any of this information, now I see there's a problem. I thought it was a small problem. It has snowballed into a huge problem. And as of Friday, now we know that there are officers that really didn't do anything or didn't provide anything in evidence that was presented to or turned over to Ms. Williams and then turned over to me, that now they're coming out the woodworks that there are possible other guns, possible other suspects, possible other contacts, possible other connections that no one knew about up until now. And again, the case law, the court's already the case law, so I'm not going to delve into that. But we are in the position now that I understand this trial was set, or this case was set to go to trial. And I understand that Ms. Patrick has been in jail this entire time. She and I have had this difficult conversation, but I am in the position, due to her age, due to the circumstances surrounding the case, and due to the mitigation aspect, the new information aspect, the possible other weapons, other people. I mean, there's so much that has been uncovered within the last few months that we have delved into this case that we are asking for more time so we can be prepared. And not only for sentencing, but for the case in chief itself. The mitigation aspect of what we are looking into not only goes to sentencing, again, it goes to actual issues with investigations that these officers conducted, especially the lead investigator in this case. So the mitigation issue deals with her age, sentencing, and the case in chief, but now we know GBI evidence, that there's still more coming in, still more information coming in. Forensic evidence, there's still more coming in. We will be having 72-hour hearings. We have to on specific information, what will be admitted, what won't be admitted, who will be an expert. There's a chain of custody issue, and again, now there's new evidence that there's some rogue cop that now literally didn't write a report at the beginning, but apparently a couple years later, a couple weeks before trial, he remembered, now I need to write a report, and there's a new gun we need to talk about, there's new, again, forensic evidence we need to talk about, there's new contact information we need to talk about.
Okay, I just need to clarify something because as I was looking, my docket that I have, I had August 3rd as just a hearing date. August 3rd is supposed to be the trial. So if that is the case, sir, I completely understand. That is right around the corner. Yep, you got a lot of stuff to do. I thought he was talking earlier about a January trial date. And I'm like, so I did have August 3rd. I didn't have on my list that it was the trial date. So yeah, that makes sense to me. This tracks, but you got to be a whole lot more succinct about this, sir. What in the world?
Talk about, and this is not from the state. This is information that we uncovered because I saw there was a problem, and the problem turned out to be a lot larger than what it was. With
This
all
poor
of that
judge
said,
is
Your
like,
Honor,
are you done?
due to the nature of the crime, due to the fact that Ms. Patrick is potentially looking at, 2 life sentences without possibility of parole, as a defense attorney, I need more time to uncover or to just delve deeper into all of this new information that we've uncovered before I can properly say that I can represent her zealously and cover all my bases. This is an issue that I don't want to come back 20, 30 years from now and have to relitigate all of this because another officer popped up with new information that we didn't know about before. Like, this is not a grasping at straws. There's an actual issue here that the state and I need to uncover before we can properly move forward with this case. So for those reasons, Your Honor, unless the court has any questions, we are asking for a continuance so that my team that we put together that is suitable to handle all this information can actually do just that. We just need more time because there hasn't been enough time yet.
Thank you. State, you
Hallelujah.
have a response?
Thank you, Judge.
State, you approach and give your
Please.
response.
Thank you.
Please let us know what the heck is going
A couple
on.
of things. First, in basically the order that defense counsel went through them, he said that there is a new team that they put together specifically for the mitigation of issues, specifically regarding the defects documentation. We'll break that down a little bit.
Please.
First, they put their new team together and they want to change their expert, but they're only doing this in June. February, they didn't ask for this. March, they didn't ask for this. April, they didn't ask for this. May, they didn't ask for this. And well into June, they didn't ask for this. Here we are on the eve of trial, and they're now asking to change their expert. If they wanted to do so, they could have done so then. Prior counsel on the case, Ms. Williams, when she got the case, she hired Dr. Schaefer very quickly after getting the case. And they still didn't get a report for 6 months. Not through defense counsel's lack of effort in getting that. It was just Dr. Schaefer didn't turn it over. I can understand why they want to change their expert. If they want to do so, they've had 6 months to do it. They still have, from my count, 21 days. We are 3 weeks from jury selection. We're still well within the 10-day limit for the state. They can go ahead and do that sort of thing. As far as the defects records that we brought up, we got those defects records a handful of weeks ago. They are largely duplicates of what was already turned over. The significant portion of those documents relating to the defendant and her history were already turned over, already examined by Dr. Schaefer, already examined by the state's expert that we hired back in February for this. That is something that they could have done. They simply chose not to.
So the state's position is that the vast majority of the defects records that were turned over, let me say, about 3 weeks ago, are duplicates that have already been available to everyone.
Yes, either the documents themselves or the information contained therein. They are information that was out there long in advance, things going back to the history of the defendant in relation to her interactions with
Oh.
the defense.
Thank you.
And to kind of cover this mitigation issue, Judge, as opposing counsel pointed out, the case law on this largely focuses on a sentencing issue. There is no requirement that the court has to allow additional time or heightened requirements for the defense. Second, if that is genuinely an issue for sentencing, a verdict favorable to the state being reached, potentially sometime in August or September or later, should it be required, the court can always set aside sentencing farther down the line so that the defense would be able to investigate these sentencing issues. There are other alternatives other than
Delay the
pausing
trial.
The trial. Second, as far as the outstanding evidence from the GBI, that was basically a request for, I'm going to use a term of art here, bench notes, testing procedures, documentation that the testers make during their process. The defense did not ask for that in February or March or April. You don't have a rogue officer here. I do appreciate.
Y'all, this man over here, it looks like his fly is wide open and his tidy whities are showing. I can't stop seeing it. I can't stop looking at it. Now, I don't know what that is, but it looks like his fly is wide open and his tidy whities are coming out. Make it stop. Put my attention someplace else. Please, somebody.
The hyperbole of defense counsel, but we do not have a rogue officer running wild. We had an officer who tested a firearm in relation to this case, or any case, to be honest. It was not the firearm used in this case. They tested it, they ran it through NIBIN, they did all of the proper testing procedures for that firearm. It's not related to this case. Multiple firearms were tested in relation to this case. None of them are the firearm in question. This is just one of those that the defense was not aware of prior to Friday. It's the exact same thing as all the other firearms we have. There's going to be.
Oh, I don't like this. This has made me not particularly care for this defense attorney. You all know I can't stand someone trying to twist stuff around. I understand zealous advocacy for your client, especially if you're a defense attorney. I am all for that. But you cannot take the facts and twist them and restate them in a fashion or manner that distorts what the actual facts are. That's when you lose me. Then you're starting to turn into Hank Brennan. And I have issues then. Or bad Jennifer. I could go on. There are lots of them.
Potentially 2 new leads to chase down, but those things are law enforcement officers. They're going to be here. They may be brought up by the state for cross-examination. If not, the defense can put them up under their own subpoena power in their case in chief. There's nothing to that would require any additional time. Again, the rule here is the 10-day requirement. We are 21 days out as of right now when I stand here in front of the court. We think that there is no necessary foundation legally for the state to continue this case. We think factually there is no requirement that the court continue this case. We think that overall the needs of justice do not demand a continuance in this case. Instead, they demand that this case be reached for trial on August 3rd as set.
Just out of the abundance of caution, while I know the rule Sunday night, you mentioned 10 days.
Sure.
And that we're 21 days out. I know that.
Yep.
Can you explain that?
I can. So the rules for discovery in Georgia require that all of the information from the state be turned over to the defense counsel 10 days prior to trial. For us, we are 21 days out as of today. That counts business days and weekends. So we do have a significant amount of time to give things to them. There may be more things coming, and I can illustrate this with something that was mentioned up in opposing counsel's brief. They were just in receipt of the defendant's calls while she is in custody. I'm going to turn those over at 10-day. Again, anything from July 1st through whatever that 10-day is. But I cannot turn over things until I have them. So they're not going to get those until then. As much as I would like to give them the calls that she is making next week, I can't turn over documentation that we don't have. The rule allows us to present evidence as late as 10 days before trial, or more specifically, to make our files available to the defense 10 days before trial.
Now,
Here we are 21 days out.
I believe you're making reference, Mr. Lee, you didn't really address this during your presentation, but in the motion that the defense presented, there was a reference to a large amount of evidence that was submitted, and there was a certain terabyte amount, I believe, that was addressed in that particular motion. My understanding is that y'all kind of resolved that, and the bulk of that were these calls that you were just turning over. Is that correct?
That's right, Judge. So to kind of unpack that completely, the 2.5 terabytes of information that defense counsel mentions in their brief, that's the entirety of the case. That is all of the jail calls, all of the phone dumps, everything.
I figured it out. It's his court badge. I'm pretty sure that's his court badge. Oh, hallelujah. I have literally been so distracted thinking that was Tidy Whitey's coming out of his fly. But I'm pretty sure if I look at it closely, that looks like that's probably his court badge. Oh, hallelujah. I'll sleep better tonight.
33 gigabytes was turned over a couple of weeks ago to the defense. I had spoken to Mr. Hoover prior to let him know these are the things that are coming. They were not surprised by any of those documents. So everything has been turned over. I think it was just a communication error between opposing counsel and their investigator in regards to what was actually turned over. There was only 33 gigabytes turned over. Again, most of that was jail calls of the defendant, and those can't be turned over until they're actually made. So the totality of what we have was turned over, not even to counsel now, but to prior counsel significantly before trial. The overwhelming majority of that 2.5 terabytes was turned over to Ms. Williams well before the trial that we were going to have in June.
Which would have allowed Ms. Williams to make her announcement ready, which she made in January. Is that correct?
Absolutely.
Thank you. Anything else to say?
Nothing else, Judge. Thank you.
Brief.
Yeah, I will be brief.
Brief.
So, Your Honor, I do
Oh,
want to start with
boy. Yeah, this judge is like, dude, I do not have time for a 2-hour dissertation about what you want.
the back and forth that you and the state had with the 10 days prior to trial.
And again, that really was just to solidify. We have a lot of people in the courtroom. Yes. People hear things. I know their family and people that are interested in this case on both sides, and I really was just trying to get the legal requirement out there so they could understand what you meant by that. 'Cause that
All of us
lawyers,
jurors in the chickadee
Mr.
coop.
Judge, we're used to these dates
We
and
wanna
these
know.
time frames, but a lot of people in the audience, they don't know what that means. I just want a little clarification there.
Yes, and to give just a little more clarification, Your Honor, the state is correct that in the state of Georgia, they have 10 days to turn over discovery to the defense. 100% correct. The point that the state kind of glossed over that they didn't mention, that I have to mention, is that the state and Ms. Williams announced ready for trial, and this trial is supposed to go in January. New evidence literally came to existence Friday, yet like literally 3 days ago. The state can't say, well, we have 10 days to turn everything over and everything been turned over when they can't themselves say that they have all the evidence. That's the problem. We are literally getting evidence now that we did not have before. Now, what the state said was, well, this is a gun. It went through the same test that all the other guns did. It wasn't one of them. I don't know that because the officer that didn't write a report for like the last 3 years is now saying that I'm supposed to just take the state's word for it. As a defense attorney, I have to investigate this. At the point where the state makes this bold assertion that, well, this is a gun that we tested like all the other guns and it doesn't exist, we gave it back, I have to do more. I have to see those tests. I have to first, before the test, I have to figure out how he came up with this quote-unquote hunch. I mean, we're in a murder trial, a double homicide, and now rogue officers are bringing in evidence that no one knew before and saying, well, I got it off of a hunch. The state didn't bring that up. The state wants to say that this is just another gun that didn't test as the fire weapon, or the actual weapon is arrest. I can't go with that. The court can't go with that, and a jury can't go with that. As a defense attorney, I have to first start with, what were you doing to where you didn't write the report at the beginning? Who was your commanding officer? Did you follow procedure? The state wants to say, well, we have 10 days to do all. Well, we don't, Your Honor, because now that's a whole new part of my investigation that I have to do once I get those reports. We still don't even have everything from this officer. And again, it's not the DA's office, but we don't have enough from this officer. So when the state says, well, we're still within, 10 days of trial, the state can't stand up here right now and tell you that they know they have all the evidence because it's not possible at this point. They announced ready for trial in January, and we're literally getting new evidence right now. When it comes to GBI and
But
the
it's
bench
not
notes, the
significant
state wants to say,
evidence.
well, it's just
Stop.
bench notes. It's more than that. Law enforcement did something. They turned over evidence to GBI. I knew there was something wrong with what law enforcement did, because I thought it was a chain of custody issue. Come to find out, GBI literally had to restructure everything and go back to law enforcement. So we're not asking for just bench notes. We're asking for
What is he
happened
talking
at the
about?
beginning.
I'm lost.
What went to GBI, what GBI had to relay back to law enforcement, and what GBI officially did afterwards. So the state's trying to minimize what information that we're still looking for, and that's just not, that's not the case. We're not talking about, I understand, an interview. We're talking about more than
It's
that.
like, I understand,
In
sit
regards
down.
to defects records, Your Honor, we asked for Ms. Patrick's entire defects file. The state wants to say, well, they had some of the information, turned it over to Ms. Williams, and Ms. Williams' expert talked about it. Agreed, they had some of it. We're talking about, Ms. Patrick was a juvenile at the time, but we're talking about over a decade's worth of defects records that not only the state didn't have, Ms. Williams didn't have, and their expert didn't have. So the state's trying to cherry pick, well, this is just this little bit and this little bit, so it's not that important. Well, it is.
Okay. Debbie, can they still investigate during the trial? Of course. We see this all the time. We saw it in Karen Reed's trial. Poof, all of a sudden, in the middle of trial, we find out there are these people that the feds hired that have these reports that are available to be used in trial. Yes, absolutely. And what the DA was saying is this is all about mitigation. You can go ahead, if we get a guilty verdict, you can still go ahead and delay sentencing until all of this investigative material has been handled, and then you can sentence. But this is not, my understanding is this evidence is not earth-shattering in any sort of way that's going to provide reasonable doubt, questions, or suspicion on anyone else, as much as he tried to make it sound like. They've ruled out the weapons. I don't know how that is now some sort of doubt. Like, sir, what are you doing? Stop it. Just stop it.
It's because, yes, there's a rule for 10 days. And just to back up a little bit, the state said that I've been in this case since February, and I just started asking for June. 100% correct. I've literally been in trials around the state when I was told that I'm taking over this case. I couldn't take the case in February, a double homicide, and be prepared to argue motions and say, this is what I need at the end of February. I mean, the court knows, as an attorney, previous attorney, that's not how murders work. That's not how cases work. I picked up the case in February. I didn't get a new team or new experts to figure out new information. I put my team together once I was told Ms. Patrick's original team was gone, and now this is my case. I have to put a team together. The state will say, well, now I'm asking for new experts, and it's June. That's not how this works. This snowballed into a new evidence has been uncovered. More information has told me there's more evidence getting outside of brief. To wrap everything up, Your Honor, there has not been enough time now that there's so much more information.
Y'all, I don't know if you saw the judge's face. We're going to back that up because they were giggling. I was not seeing that he was jokety about this. Y'all tell me what you think.
New experts, and it's June. That's not how this works. This snowballed into a new evidence has been uncovered. More information has told me there's more evidence getting outside of brief. To wrap everything up, Your Honor, there has not been enough time now that there's so much more information. And at the point where the state can't stand up here in front of you and say, Your Honor, we have more than 10 days left, that's the rule, and we can guarantee that all the evidence is turned over. They can't say that because they don't know that for the fact. At this point, we have to have a continuance. The state literally asked or announced ready, not knowing all the evidence in the case. As this dispatcher's attorney, I cannot do that. I will not do that. I will be ineffective, and we are asking for more time because there's more evidence out there that we do not have yet.
Thank you. I do want to make one slight correction. I believe in January, the state actually announced not, it was Ms. Williams' defense counsel that announced ready, and I believe it was the state that announced not ready. If they both had announced ready in January, I would have tried the case in January. I believe it was the state that announced they were not ready, and I believe the sole issue, the only issue that was left in January was a report from the doctor. There was a preliminary report that was provided to defense counsel, which defense counsel then provided to the state. Defense said that they were ready and able to proceed with trial in spite of not having full reports. That they thought they were sufficient, adequate, and prepared to do a full and proper defense of Ms. Patrick with just a preliminary report. The state announced that, Judge, we see some issues in the preliminary report, and we believe that we cannot be prepared without the full report, and we need to be offered the proper opportunity to have our own expert review the full report. That, as the state, we're entitled to that privilege. It was at that point that I decided to continue the case, and even acknowledge that I believe Ms. Williams, she even needed the full report. And I believe I even placed that on the record at that time, that even though she was willing to go forward with the preliminary report, I believe that she did need that full report to do an adequate job. And I believe that was the sole and only reason for the continuance in January. I've listened to both sides. I should have a ruling within. I need to have a ruling either way very quickly so that everyone knows what to anticipate. I do have court the rest of the day today. I have court tomorrow in a separate county. My intention is to have an order to y'all. I'm going to say no later than midday Wednesday, but I really want to have that order out by tomorrow afternoon. So give me till midday Wednesday just in case something happens. But I really am shooting forward tomorrow afternoon to have that order prepared. As I indicated to y'all when y'all came up to the news conference, the only thing that can delay that, however I rule, I really do want to make sure that I have the procedural history correct. I've already asked my court reporter to pull the transcript from January, so I make sure that I get that language correct if needed. I need to use that in my order. So that's the only thing that may take me a little bit more time. It's just making sure I have that procedural history accurate to support whichever ruling I make. I appreciate you both of y'all being here today. Appreciate the arguments that have been made. I'll have the order midday Wednesday, if not by tomorrow.
And Your Honor, just with that said, Bruce, I apologize. I wasn't here in January, so I didn't know.
It's okay.
I need to say, the state asked for a continuance, was granted a continuance in January because there was one sole issue, like the court said, that they need to be prepared for. I am now saying there's not one sole issue that I need to prepare for. There are multiple issues that I need to prepare for, and we're asking for the continuance for that reason. And furthermore, it's still information the state doesn't have either. So the fact that they're still trying to announce ready for trial, when they don't have the information that I'm literally saying we still need, says a lot. So the state asked for a continuance for one sole issue, it was granted. The defense is asking for a continuance for multiple issues, and it's not something small, it's something major. The state still doesn't have that information.
Mr. Hoover,
We're asking for it.
you've already made your point.
That's going to make sure.
And I do want both sides to be aware.
Sir, your side certified way back in January that chop chop, we're ready to go to trial. I don't know why you're standing here. I don't know what has happened. And just so you all know, I'm doing some research while this is happening, and everything says it was continued gotta get my docket, that the trial was continued to August 3rd. Well, that's the date I had. So I must have had maybe an earlier date, the end of this month, maybe. I don't know, but this puppy's going to trial on August 3rd.
Giving you a little leeway today. But just random arguments that are made after I've given you time to make your arguments, we'll follow a slightly different decorum for court. Yes, sir. This is not a time for argument back and forth in a debate type fashion. It's an order, right? We take a specific order. You presented, state presented, I gave you an opportunity to make rebuttal. And then I've announced when the ruling will be made. I think that should suffice. Okay, I appreciate your zealous argument. But I will not let this case get out of hand. I just want to set the tone early. While I appreciate the zealous advocate that you are, and I need you to be that zealous advocate for your client, right? That's how you're supposed to represent your client. The state needs you to do just the same for the state. All parties will stay within the realm of proper court decorum. Okay?
I don't think this judge is going to let shenanigans happen.
Noon, if not by tomorrow. All right, thank you.
Okay, let's get to some things happening here in the chat. I need to take a little sip, though, because I got a tickle. Little drummer boy, I am so sorry to hear that you have not been feeling well. That's awful. I hate that for you. I am doing much better. Thank you. I'm glad to see that at least you're out of bed. Let's see. I think he must have denied it, Kelly, because the August 3rd trial date was set in January. And so that's why I was confused with things. I'm like, it is, it isn't, it is. Yeah, Hightower was like, we ain't doing that here. He sounds to me a lot like a Judge Everett type of judge. I can get behind that. Or Judge White, I believe it was, in the Ashley Benefield trial. He was also, I really liked him as a judge as well. Debbie is asking, will I be covering this trial? Well, it starts on the 3rd. And we have to talk about Ms. D's schedule. Opening night is August 14th. So the first 2 weeks in August are going to be my heaviest and biggest rehearsal time. That's when we start full run-throughs in full dress rehearsal, costumes, sets, the whole thing. And so I don't know that I'll have time to cover it during the week, but I won't be able to cover anything the week ending in the 15th because that's opening night. I will have rehearsal every night that week. Then the show starts on Friday night. Then I have a show Saturday night. And then we also do a Sunday matinee. So the earliest I'll be able to get to anything for that particular week is going to be likely Monday. And there's a very strong possibility that we, depending on how this court operates, you know, we may or may not be able to zippity-doo-dah through a lot of things and cover a lot of this. Now, the weekend before, absolutely. I will try to that weekend before, just like I'm doing this Saturday night stream. So probably over the next 3 weeks or so, the streams during the week are likely not going to happen, and we'll be doing Saturday evening streams instead. So that's kind of what I'm thinking and picturing in my mind. Once the show starts to run, I should be fine with the Monday and Wednesday night again, because performances are Friday night, Saturday night, and Sunday matinee. So that's what I can tell you about all of that. Yes, this is absolutely one of the cases I want to cover. There is a bunch of stuff that's getting ready to pop off in August. If it all goes down the way they're saying, there's going to be a lot of true crime for us to cover. So I'll do my best. But we are officially off book. Everybody in the cast, we will start rehearsal on Monday, and the expectation on Monday is that we are off book. That means you don't know your line, you have to go line, and someone tells you what your line is. But we are off book. All right. I think we're caught up on the Sarah Grace Patrick situation. Let's go next to the next one I have. I need to look here. I think it's the whole thing, and I have it queued up incorrectly. So
you all,
I do have it queued up wrong. This is Shanna Gardner. Does everyone remember Shanna Gardner? This is Shanna Gardner. I gotta look at his name because it's 3 names. Mario Fernandez Saldana. They conspired to murder Jared Bridegan. Do we all remember this? Lured to the house, supposed to be an exchange of children, and he was murdered at that time. So that's what this hearing is. This is for both Fernandez Saldana and Shanna Gardner. So, and I hope I'm saying her name right. I have not actually heard it. I don't know if it's Shanna or Shayna. I say Shayna. Maybe I'm wrong. I don't. If I am, girl, I'm sorry. Don't mean to be, slighting you with your 15 minutes of fame because your husband. So, let me get us queued up for this. Are y'all ready? The next hearing. So we've got a trial going to be starting August 3rd that we're going to have to try to follow. I will tell you this. I am going to try desperately to be able to do morning TikToks. I used to do a morning TikTok just about every day last summer when I was following some cases. I have gotten away from that. My morning schedule is really difficult with my new job. And so it's hard for me to do a morning TikTok. I'm going to try to get back to that. And I will also give updates there. So that might be a good place to get some little snippets throughout the week prior to me having any sort of live stream. If I can't do it in the morning, I may try to do it from my car at lunchtime. So either or, I'm keeping my fingers crossed I'll be able to get that done. All right. Y'all ready? Let's do this. Okay, let's zippity-doo-dah to actual. Is she coming in now? I don't want to skip through that. Ms. Gardner, are you here? Have you arrived? Ms. Gardner. Hello? He looks almost like he's struggling with the door. Ah, there she is, yes. She's must have scooted in without us seeing. Imagine that. I'm going to try to get us. Oh, no, there she is. I saw the dark long hair. Thought she looked a little too put together there. She is so proud. Oh, she's a very tall, like lurchy looking woman. I don't guess I ever realized that. All right, let me get to when the judge comes in. My bad.
so,
Nope. Oh, oh,
okay. Miss Medina. So, okay.
my bad.
Can you hear me now?
Okay, we got some people on the Zoom.
Good morning. I
Okay.
apologize. We're unable to hear the proceedings.
Okay.
I'm trying to figure out where to put myself. So that might be.
Can you hear me
best.
now?
Can you hear me now? Can you hear me now?
Mike, can you come up?
Your
Mr.
Honor, I think
IT
it may be
man.
on her end because we can hear.
Ah,
I'm going to ask Frank if you can hear us.
Mr. Tassoni?
Yes, Your Honor.
Okay.
Frank can hear us. I don't
Mr. Carodi, can you message Miss Nelson and say that she needs to look at her device? Everyone else can hear.
Yes, Your Honor.
Miss Medina, can you hear?
Yes, Your Honor.
Okay.
I can.
Okay.
okay. I'm gonna.
So I know that I owe an order on the wiretap, and I just want to clarify. I did deny it, but I just need time to edit. I was in first appearance. I've been in trial, so
That's fine, Your Honor. For the court's information, since our last court date, we have taken a number of depositions. We have depositions, the last remaining ones set for this afternoon.
Y'all, I have to tell you, I am loving this judge's hair. I am here for Judge Kite's hair. Girl, I love it. Just had to get that out.
We have depositions for next Friday, the 17th, for Ms. Gardner's listed witnesses. And I think that should conclude the discovery depositions absent, maybe one or two remaining witnesses.
okay. Does the defense agree?
I think within small numbers or entirely, yes. Meaning there could be a couple that I'm just not thinking of, but we are nearing the end, and it may be that we're done.
Okay. So from Mr. Fernandez, his legal team's perspective, is there anything that we need to do? I indicated that I'm going to go upstairs with the lawyers for logistic purposes, so that I can have, I can answer any questions and also like kind of get an idea of, what you all will need in order to try the case. So,
The only thing that I would ask is out of abundance of caution that if the state and I cannot come to an agreement regarding this afternoon's deposition, that we get some hearing time on Monday or a to-be set, whatever the court's preference is.
I'm going to do it on Monday. I do have 2 jury selections, but I believe one of my colleagues is going to select for the second one. And so I'm going to move my jury selection to 1:30. And then my thought is I can handle these motions that relate mainly to discovery earlier rather than later. So I would handle them at 11 a.m.
All right, so you want defense counsel here at 11?
Correct.
Yes, ma'am. We'll be here. So this upcoming Monday at 11.
Right.
And with-
July 13th at 11 a.m. hearing a motion.
And if this gets resolved, if we could just email your judicial assistant, and then you could just give us another pass date that you see fit. I do think there's at least a 50-50 shot that we resolve this by tomorrow.
Okay. If you don't need the time, that's fine. I do want to have a final pretrial. I did not set that initially. I'm a little bit hesitant to do it the week before like I normally do. Do you want 2 weeks before, like the 27th?
Yes.
Yes, and then whatever.
And this is for Mr. Fernandez's case. So his final pretrial will be held July 27th.
And what are you thinking in terms of motions in limine? In terms of like time in between those 2 weeks? I know there's a deadline set because I saw it on my calendar for when they're due, but when were you thinking we would actually hear them?
So you all take priority over anything. That's what the priority order is. So if you need me to handle them, you just let me know and you advance on my calendar. So I'm depending on the parties, because you all know the substance of the motions, to kind of let me know how much time you need. All you have to do is let me know that, and I will advance you on my calendar.
Yes, Your Honor. I'll get with Mr. Dreiser and see what they're going to file, what we're going to file, what we agree upon, and what needs court time.
Just to give you reference, Mario Fernandez Saldana's trial is set to start on August 10th. And Shanna Gardner's jury selection is supposed to begin on August 31st. So those are spread out a little bit more. Her trial is actually not supposed to start until September. So we may be able to buy ourselves a little bit of time, and this won't be like boom, boom, boom. So anyway.
Okay, so if you need the time, I'll give you the time. You don't even, all you have to do is ask, and I will.
Understood. Thank you.
Okay, but just to be clear, so Mr. Fernandez's case will be passed to July 13th, and it's, let's do it in, do you know, is, Ms. Janako, is 407 available
It should be, yes,
next week?
on the 13th.
Yes, so we'll set it in 407 for hearing time.
Yes, Your Honor.
Okay, 11 a.m.
There was one last issue that we had taken up with the court previously regarding an agreement between the parties as to the testimony of a minor witness, minor victim, BB. The parties have come to an agreement. We're going to put it in writing and file it with the court. And the agreement is that the state is not going to call BB as a witness at trial, so we do not need to have any litigation on competency issues. The defense has agreed to the admission of a video from the scene of the minor child and to waive their confrontation and legal objections to testimony by 2 civilian witnesses as to her statements on scene. I'm going to put that in writing as a
Wow.
stipulation, and the parties will sign and we'll file with the court.
Okay.
We also agreed, we're coming to agreements as to certain witnesses that may appear via Zoom. We have agreed that AB, which is the initials of another minor that we expect to testify in this case, will appear via Zoom.
Will appear?
Will appear via Zoom.
She's a listed witness for the defense. Mr. Dreiser intends to call her. Mr. Carodi has accepted subpoena service from both the state and Mr. Dreiser for AB, with the understanding that her guardians would consent to her testimony in Mr. Fernandez's case via Zoom. So we'll sign a stipulation from both state and defense as to Zoom testimony, and Mr. Carodi has accepted those subpoenas.
Okay, so if the stipulation, I want you all to go over, there's a 5th DCA case, I believe, I can send it to you, that you go over that particular case with your clients, Mr. Dreiser with Mr. Fernandez, and the state. I'm going to send the copy to you. So this, there's a requirement, if there's an agreement, it's not that big of a deal. However, prior to Zoom testimony, there has to be confirmation that Mr. Fernandez can see the witness can see Mr. Fernandez. That is a main issue, and I don't think that it should necessarily be an issue because of 407 and how it's going to be set up. But all those things have to be confirmed for the record. And then it specifically addressed the confrontation waiver. Okay?
Sorry. And we should be able to take care of that. She's a defense witness, so I don't think.
She's also listed by
I think the waiver of confrontation will be something we can take care of.
And then having said that,
It was actually in this courtroom. I think Judge Soud wrote, it was an affirmance, but Judge Soud wrote
Yes, sir.
a concurrent opinion that I think gives guidance to any remote technology.
so with that instruction for our future conversations, I just assume that the court, if we had an agreement as to witnesses, you would not necessarily have it.
Yeah,
An objection.
it does not matter to me.
You just want us to make sure we run all those people by our clients so that
Right.
you could do a inquiry if need be.
I will do an inquiry. We can do it, just kind of as a group, but I don't want any issues related to what their rights would be. So if you just, it's an easier process if they know kind of what the law is, and then if they want to waive it, they can waive it. I don't have any objection to remote technology. I think it's the wave of the future, but it just has to comply with, meaning, so one of my, I remember substance. I don't necessarily remember names, but I can tell you there are two cases that come to my mind. One is from me, this court, 5th District, a binding appellate court decision. It was an affirmance, but it was instructive how basically the court, one of the judges from the court felt about the confrontation clause. I think it's instructive. Two is that there's another case that comes to my mind. I cannot remember the name, but I will get it to the lawyers, that basically wherever the witness may be, okay, it has to be impressed upon them that this is a court proceeding, that there is seriousness in their testimony, that they understand that the oath, and that they understand that they could be held responsible for any perjured testimony. And so with all of those kind of in mind, when you are setting up your Zoom, when you are setting up your remote, it needs to look professional. They need to know, even
It's
if
court.
it's a minor child, that this is, an important proceeding, especially on a minor, because, maybe there's a modified oath given, and y'all need to talk about that, if you want a modified oath or you want the regular oath, but it needs to be impressed upon them that this is a court proceeding. And so with all of those kind of taken care of and thought about, I don't have any problem with it. You don't ever have to worry that, the judge won't let it. That's not my idea. I just need to make sure that they understand, kind of the seriousness of these proceedings.
By the way, little drummer boy, this is another Florida court. And Florida knows how to make some courtrooms, let me tell you. And I wish this were closer distance to me. This is not really a feasible driving distance for me, unfortunately. But yeah, another beautiful courtroom.
And for
With
Mr.
a judge
Fernandez,
with
I think
rockin'
that
hair.
Covers it, and then we'll wait until we go upstairs.
Okay.
Thank you.
Your Honor, my understanding is that we also have a,
Come on.
I'm sorry.
She's like, get your booty up to the lectern, sir.
Your Honor, my understanding is that we'll also be here Monday at 1100 for a motion.
Yes. So I haven't seen it yet, but I've heard it's been sent to me. I did read the materials by the defense on the subpoena request, and then I haven't read the state's response, so I will do that.
And then with the agreement related to the minor child BB, I believe it would be appropriate for the court to deny our pending motion as moot related to excluding her testimony.
Okay. Could you do a form order for that, Mr. Hathaway?
Yes, Your Honor.
Okay, thank you.
And Your Honor, while Mr. Carodi is here, I wanted to bring up one small issue, and it has to do with the court's order regarding the timing of the filing of the motion in limines.
I can adjust it.
But the state's thought process is we're going to
Oh my gosh, sir. You are an educated attorney and you just said motion in limines? If you follow me on the Twix, you know this came up earlier this week for me. It is motions in limine, not motion in limines. There aren't multiple limines. There are multiple motions. Why can people not speak the English language correctly? Yeah, exactly. Lemonies. Motions in limine. Oh my goodness. Not motion in limines. Ay, ay, ay. Yeah, there's all kinds of lemons falling all over the place, right?
Be in trial when their deadline is. So I understand there may be things that come up during the Fernandez trial that causes the defense to file a motion in limine. And
Tell me what the overlap is.
It's
What-
5
what's-
days. So it's 5 days before the commencement of each jury selection. The state's thought process is some of the motion in limines will overlap. And
You just did it again.
as practical as we can make it, I would like the Gardner motion limines to be filed 5 days before the
It's 3 times.
Fernandez motion limines. So in other words, we can hear them all at the same time.
Motions in
Understand
limine.
that Maybe something that creeps up in the trial that we have to hear, but I don't want to be this situation where the state's in trial and the defense is filing motions in limine that we have an opportunity to respond to or litigate before the Gardner.
What's the defense position on that? Do you have, I mean, well, let me ask it this way.
The defense's
Are
position is
there
it's motions
that
in
y'all are
limine.
contemplating that could be filed ahead of the Fernandez jury selection?
Judge, at this time, I can't tell the court that there are any specific motions. I'm sure there will be. We have relied on the court's order, as to that deadline.
Right.
Mr. Wright, he brought it up to me this morning. I'm just not in a position
Okay.
today to address
Can you talk about it and we address it on Monday?
Yes, Your Honor.
He's prosecutor lemonies. He is prosecutor lemonies. Not just one lemon, many, many lemons. Oh, what was this from? Oh, Harry Potter, correct? Oh, what is this from? You're going to drive me crazy now. Isn't that what it's from? Is that the right Hermione I'm thinking of? I'm probably off base, but I do vaguely remember this.
All of you all are very, very experienced lawyers, so I'm hoping that we're not going to be litigating things that are just accepted law. You know what I mean? It should be related to perceived evidentiary issues that are real. You know what I mean? Not boilerplate.
Yes, Your Honor.
Yes, ma'am, of course.
But I mean, to the extent, it's hard for me to do that because when they're separated in that way, I mean,
From the state's perspective, having it 5 days before Fernandez, just like the Fernandez order says, doesn't put an undue burden on the defense to have their motion limines done, 3 weeks before as opposed to 5 days before. I don't think it's that unreasonable. And the same would hold true for the state if we have any in the Gardner case, that we would file it early. I just think if we're going to have motion limine hearings the week of the final trial, we should do both defendants as much as we can. I mean, I'm not going to say if they can't raise something up, but we're trying to comply with the court's order. I just didn't want to be inundated with some motion limines while we're in trial. That's what I'm trying to prevent.
Your Honor.
I'm in
I can
2
say
hands
first,
now.
We'll try and file motions as soon as we know we're going to file them. Second, though, I do respectfully disagree with Mr. Mizrahi. When the trials were severed and they were set, that sort of set our preparation timeline as to how we are preparing. I believe that, the additional 3 weeks that we have, we're working it into trial preparation. So I don't think that we should be held to the same timeline as Mr. Fernandez, who has had ample notice of his deadline for months.
okay.
Well, now we have a conundrum.
I will, I'll take a look at it. I'm going to ask the lawyers to take a look at it. Maybe one of the ways to resolve it is you all have been adopting certain motions filed by, Mr. Fernandez's team, and to the extent that it may apply in your trial, maybe that's one way to resolve some of those issues. You see what they file, you can decide whether you adopt it or not, handle it at the same time. But I mean, my thought process in setting the deadline the way that it was is that I was kind of told by, like, you may not take all the time. So there may be time that we are on break or done with the Fernandez trial and we can litigate in the Gardner trial. But obviously I wouldn't put the state in a position where you couldn't be prepared. I wouldn't be unreasonable. So if you did need the time, I'd give it to you.
I don't find her to be
So I
unreasonable
don't
at all.
necessarily think that is a concern, but maybe one of the
She
ways
is
that you
not
can
giving
resolve
Judge
it,
Cannoni vibes
you
at all.
see what Mr. Fernandez's team files, and then
What
you
was
can
that
see
twit
if you
judge's
want,
name
we can have
in
it
Edric Faust's trial?
kind of at the
What's
same
that-
time, whether
what
you
was
want to
that
adopt
little
or you're going to let that one, it doesn't apply to your
dork's
case.
name
And then
that
the state
refused to wear a
can
robe?
have those rulings, at least the preliminary rulings from the Fernandez case. But my general thought about motions in limine is like, it's hard sometimes to rule in a vacuum. So some of these things may have to be deferred anyway, for proffers and things of that nature. So I don't know what you all are intending,
Lot.
but Mr.
Lisa
Mizrahi, maybe it'll
Lot.
make you feel better.
That's right, she
I
was
would
a
not
lot.
make you respond to something that you're not prepared for. So,
Thank you, Your Honor.
I just want to bring up the issue else.
She is not Judge Cannoni, and
All
she
right.
is not Judge Lott
have you all met?
or
with
Gilday.
Yes, Your Honor.
Okay. Especially if y'all are going to be using Zoom and things like that. Y'all, the defense team, you've met?
The Fernandez team spent a whole morning following your report.
Okay.
We met with everybody from ample light, court administration,
Okay,
through all the technology in the court.
great. All right, well, so I will see potentially
y'all are
both cases.
BFFs
depending
now.
on what y'all's agreement would be. On July 13th, 11 a.m., courtroom 407, hearing on motion.
Thank you, Your Honor.
Yes, Your Honor.
Thank you. All right.
All righty. And that is all she wrote for Shanna Gardner and Mario Fernandez, I think is what they call him. Let me get us up to the next docketed item that we have. Oh, and I don't have, I might have this one queued up correctly. So bear with me while I prepare my, oh, that's not it. Nope, nope, nope. This is the one I need. We're going to head to court to hear what the heck is going on with good old Brad Simpson. We all remember Brad Simpson, right? Brad is accused of ending his wife Suzanne Simpson's life. If you recall, there was a neighbor that heard a scream around 11 p.m., saw some strange things around the property, and Suzanne was never seen or heard from again. I agree, Mrs. Georgia Mom. I love to see intelligent, strong, even-tempered women in positions of power that are just bad booties. I love that. So I'm very much looking forward to seeing her preside in this courtroom. And we likely won't watch the Fernandez trial, but I may end up doing the Shanna Gardner trial. The Simpsons. Yes, they are the Texas Simpsons. It's another Brad. We have Brad Morphew. Nothing that I'm doing on him this evening. But we do have Brad Simpson. And that is what is going to take place in this next hearing. Let me check my docket to see what is happening with him. There is another hearing that is set to take place on August 31st. And that's really all I know that is going on here. This trial, I'm fairly certain this is the one I'm thinking of. This trial feels like it's already gone off the rails because there's just been a crap ton of discovery. And so it has been continuances galore. And I'm super excited to see what the heck all of it is. So let me get it queued up for us, add it to the stage. Are y'all ready? Let's find out what's happening in old Brad's life here. And I don't know where I need to put myself again.
Are other lawyers here on Brad Simpson? Wait, what is the state? Oh, you're all here, right? I'm sorry, there's so many people in here. Okay, ready? Yes, sir. 2024 CR, is Mr. Simpson on here? Okay.
Sure.
2024 CR 012097, 2024 CR 012.
Boy, he looks different.
And 2024 CR 012095, this is Brad Chandler Simpson. Will the lawyers please take their names?
Casey Sandoval, Michael DiReal, and Ashley Haas for the state of Texas.
Stephen Gilmore, Brittany Durham, and Tanya Rivera from Mr. Simpson.
And sir, are you Brad Chandler Simpson?
Yes, sir.
Okay, so the lawyers, we were here back in, I think, May, the 14th, and at that time, some matters were presented to me, and I think I ordered that we were going to have an in-camera review of certain matters related to some witnesses and the like. That in-camera review has been completed, and I will provide the lawyers a USB drive with the contents of what I find to be disclosable. Okay, that's on that in-camera review. Now today, I've been informed that there's other matters that may be disclosable to the defense, and I'm going to go ahead and based on what we discussed earlier today in chambers, that those matters be disclosed to the defense, and then for you to give you some time to review. I'm not too sure if you know how much information is contained in those things that are going to be disclosed to you, but for now, I'm going to give you 45 days is what you're requesting, correct? At least to get up to speed on that.
That was what the court suggested, yes, Judge.
Okay. And then the state, are you in a position to disclose those matters to the defense?
Are you speaking about the civil?
Yeah, the civil litigation.
Judge, if we could, if I could reconvene with you on that. I'm waiting for an answer from our civil division, but yes,
Okay.
I mean, we do have the.
Let's do this, because I did say this. Let's just the lawyers, not a hearing, just because I still need to give you that USB drive. So if the lawyers can come back just for a meeting with me this Friday.
Yes, Judge.
And by this Friday, let me know what the position is of the state, which my understanding is that litigation is disclosable, but if you're going to have some objections, you need to let me know, depending on what the civil side of the DA's office tells you. So let's just reconvene on this Friday. Anyway, I need to give you those USB drives. And then we also discussed other matters regarding after the 45 days that I'm giving the defense to look at those litigation, unless you object by Friday, that I want you all to reach some mutual agreement regarding a potential witness list. Of course, I'll still have discretion on that list, but to narrow things down, start getting ready for trial on the.
So the civil litigation that they're referring to, I don't know if you all remember or not, but there was a business associate of Brad Simpson's that was involved after the fact. And he, if I'm remembering correctly, pled guilty to some of those charges. However, there are civil matters that are also related to this particular case in whole. And so That's what the judge is referring to when he's saying, I believe those matters are disclosable. And I think he is absolutely correct. Hey, KS Granny, thanks for the Sunday. Giving us a Sunday on Saturday night for our wine and crime Saturday. And Debbie, I saw that you said you didn't know about this this particular case. I did do an entire live stream where we did a deep dive into this. So go back and look at some of my past live streams, and you will be able to find his name, Brad Simpson, and you'll get a lot more details. We did a tour of the house, and we did a rundown of the timing of the case and how the parties were involved and what the business partner may or may not be involved in. So there's a lot more information in that prior live stream that I did where we did a deep dive on this.
The actual potential witnesses. The other thing is I'm ordering you to also start conferring on body camera redactions, because those do take a long time during trial if you all have not reached agreement. And lastly, maybe depending on the amount of evidence that you need to offer, at least narrow it down. We're trying to avoid, and I know that the case law that we're talking about is not in particular to what we're talking about here, but let's try and narrow down the evidentiary matters that you're going to attempt to introduce, so that we can start narrowing down.
That man looks lost.
The parameters of this
Like,
trial.
where am I?
Since everybody is telling me that this is going to be a long trial, I'd like to have some judicial economy on it.
Long
And
trial.
Then, again, in the absent any mutual agreement, then you all come back to me and I'll make the decision on that.
Yes, sir.
Okay? Anything else that I'm forgetting that needs to be said today?
Nothing from the bench, Judge.
Nothing from the state.
Okay, so the formal reset is for 45 days from now, and it's going to be, again, just a status to make sure that he has received the matters that I'm talking about, number one, and number two, that he's had time to review them. And then the other thing I did discuss was that at some point, I'm going to set a deadline for discovery production, because of the factual situation of this particular case. I'm imagining that discovery keeps coming in, but at some point, we got to stop that and give them a deadline, and then that's it. Then we go to trial. Okay? So, anything else for me to decide at this time?
Nothing from the state.
There you go.
Okay, then I'll see you here on Friday, just the lawyers, and then a 45-day reset for the defense to have time to review those matters.
Yes, sir.
Thank you, Judge.
Thank you very much. That closes the record. Thank you.
Oh, Brad. He does not look nearly the handsome man that he was when Suzanne was still with us. This is not the face of a handsome looking man. The 45 days out, I believe, is August 31st. That's what I put down on my hearing, pre-trial, trial calendar, my docket diary. So bye-bye, Brad. Until next time.
Anything else, Randy?
Kind of looked a little bit like a toad there as he was walking out. He had that little toadish kind of walk about him. Okay. So now we've got an update on that one. Oh. Has anybody at all been following Keffe D, Duane Davis? Anybody? Bueller? Anyone? Because that's what we're going to watch next. And I got the impression, based on some feedback I saw on the Twix, that this may have been a little spicy. So let's see. I do still have wine left. So I'm ready for the spiciness. I do not have any popcorn that I could be. But we're going to watch, if you don't know who Keffe D / Duane Davis is, Keffe D is being prosecuted at this time in connection with the death of Tupac Shakur. This happened many, many years ago in Las Vegas. It has been rumored to have involved him for quite some time. And then he had this really brilliant idea that he was going to write a book. And boy, oh boy, after he wrote the book, when the walls come tumbling down. Yeah, that's what happened. Oh, Keffe D. Yeah, not a good thing. So this is getting close to trial time. Also, let me see. Do I have a trial date? August 10th is when it's supposed to go to trial. So this is like some of the final pretrial hearings that we're getting into.
He was a shock.
And I'm going to back us all the way back up to the beginning. This is an hour-long hearing. If we feel that they're talking a little too slow for us, I can always put it on misdemeanor speed. And I don't think there are many dead spots in this in which I can zippity-doo-dah us. But if there are, I'm going to do that as well. So we're going to get into this one to find out what's happening. Keffe D also looks very, very different now than he did back in the day when Tupac Shakur did lose his life. So you've got that to look forward to as well. Let me do this. This gentleman standing right here. Oops. Right here in the jail garb. That's Keffe D. Yes, Kelly, I think so too. He got some bad advice on doing the book deal. Keffe, we needed to chat before you did that. Not a good choice. We talk about making good choices. You didn't make a good choice there. So.
Due to the
let me back us up.
Page 4, Duane Davis, C377407. Here you are, Mr. Sampson. See you come in. All right.
And I am trying to place that attorney. I can't place him, but he looks very familiar to me.
We're on for 3 motions. Let's start with the motion to sequester the jury. Mr. Sampson, did you want to be heard any further on that motion?
I mean, it's an unusual request in this jurisdiction with regards to sequestering any jury, but due to the level of media attention that we have on it, the fear and the danger is that the individuals go home at night and listen to commentary, maybe not directly, but through family members, something along those lines. And so we're always concerned about that. That's why we apply.
I think sequestration worked pretty well when not everyone had a phone that did absolutely everything in their lives attached to them. I don't know how we could separate the jurors from their phones for an entire 30. We have to take them essentially to accomplish the goals of sequestration that you're laying out. Additionally, if we did that, then they'd be alone in a hotel room, no phones, away from their daily routines, probably watching TV, which would then have coverage. So my concern is that sequestration might actually not resolve any of the issues that we have. But I do understand the concerns while jurors are in the building, that there may be communication with people, so we could do some sort of like partial sequestration while they're in the building, going kind of to the back for lunches and things like that.
And we have talked about it with the state that if, a full, how do you pronounce it,
Sequestration.
Yeah.
If that's not going to be granted, that yes, absolutely, maybe accommodating jurors through the back elevators so they're not in the hallways coming up.
Of course.
The courthouse would be a way to sort of protect them while they're in and
That's
out.
a silly request. Of course you would do that.
And maybe have lunch forums in the jury room type thing. The other thing I was going to
We've
raise.
reached out to another department that did that in a case, I think, last year, and so to get some guidelines on how that worked.
Yeah, that was going to be our position as to, we've done a lot of high profiles and that's it. It's like a daily sequestration, but they have to go home at night.
Yeah.
The only other thing I was going to suggest is, as it relates to jury selection, once we go through some of the hardships and all that other stuff, it may be best in this particular case to do individual sequestered voir dire of the jurors themselves so that
when one juror discusses their knowledge of it, we don't have to deal with that situation. I don't know if the court wants to address that after you ask who here has heard about this case, or if you want to just do it up front and make that decision.
So I think very valid concerns.
By the way, I ate lunch in the cafeteria with almost all of the jurors on the Donna Adelson case. Now, I'll tell you, when I say I ate lunch with them, I ate lunch with them like I ate lunch with Kelly Siegler. We were in the same location. I wasn't sitting there chatting with them or anything. They actually were talking amongst each other. You could tell and see that friendships had been made throughout the course of the trial. And there were some people that were partnering up and a little group of people going together. And no one was discussing anything about the case. It was in that courthouse. It is a very, very small little cafeteria area. And you could very easily hear, conversation without even really trying. I was there by myself the second day that I went. And so I ate lunch by myself in the cafeteria there. Well, of course I can hear the conversations taking place around me. And there were two gentlemen that were on the jury, and they were just chatting away. I think they were talking about fishing, if I remember correctly. And then there was the one girl on the jury that literally looked like she was positively freezing all the time. And she had a cell phone up to her ear, and I could tell she was feverishly trying to get work done on the lunch break. But they weren't sequestered. Actually having them in the courtroom or in the courthouse and access to people around them, I think it probably lended itself to more accountability because there were people like myself watching them. I would have loved to have had lunch with them, not even discuss anything about the case at all, but just to have lunch with them. But I didn't, because they have little stickers that say juror on them, and you are instructed by the judge to stay away from them. So it's like they have some communicable disease.
I think we can talk about maybe how we're going to handle that, but I do think it makes sense maybe when people raise their hand that they've talked about it, to take those people individually and see if how much they've heard about it, instead, without affecting the rest of the jury with their knowledge. So it might be sequestered for kind of that answer. I don't know. I'll take some suggestions from the parties, but what are your thoughts on that, Mr. Sam?
I had dinner last night with a professor from BYU who's 73 years old, and he heard of Tupac. Which, once again, I would have bet no, but 30 years ago, he was 40. So it makes sense that when you were 40, you put the potential. So I think we're going to get the same problem. Everyone at some point will raise their hand because they're going to be familiar with something to do with this particular trial, whether it's his music, whether it's some of the other individuals that would be named by the state as potential witnesses in this case, that they would have knowledge about that. So I think we cross that bridge when we get there.
Sure. I anticipate larger panels than usual, multiple days of large panels, and probably a lot of people that maybe ultimately cannot be fair in the situation and are excused because of their either knowledge or interest in the case, or some sort of issue with that. But I think.
Did he really just say he was surprised that this professor that was 73 years old would know who Tupac is? Dude, you're a dork and an idiot. I just checked on the date because I'm like, wasn't that like 30 years ago? Dude would have been 43. It's quite likely in 1996, your professor at BYU was listening to Tupac. Come on. What are we doing? Kelly, I tried desperately to reach out to anyone on the Donna Adelson jury. I don't think I have the correct connections for that. And so, yeah, I would have loved to have had her on. I'm always anxious and curious to know how juries think and what the conversations are like and what their the makeup of the jury is as far as their life experiences and perspectives, because that is so interesting to me. I think I told you all very early on that one of the things I suspected, and I would love to know if this is true or not, was that in the Donna Adelson trial, on the second day that I was there was the day that they played the telephone call in which Donna thought that they had hung up, and she hadn't hung up. And she's making reference and talking about the kids, her grandchildren, and some of the letters that were read. I say letters, they were emails back and forth about how she wanted to dress them in Nazi clothes or something like that. It was awful, awful stuff. And there were like 3 men on the jury when that testimony and evidence was coming into the trial that I looked and I was like, oh, this is not good for her, because the look they were giving Donna. So in that particular courtroom where the jury sat, there were several TV screens that were set up in front of them. And so anytime an email or anything like that was being introduced as evidence, they would put it on the screen, and the jury could then look at the screen, read along with it, just like us in the gallery. They were put up in corners on large monitors. We were able to read along as well. When that was happening, these 3 men in particular, there were 3 men in particular that were looking at the TV screen, and there'd be a line, and then they'd look at Donna, and then they'd look at the screen, and then they'd look at Donna. And when they would look at Donna would be in some of the most hideous spots of evidence, testimony, however you want to call that. And I would love to know. I left that courtroom that day thinking these 3 men have been in a custody battle of some sort in the past. I just, in my mind, I was like, that's why they're looking at her like that. They're reading the words, and then they're looking at her like, how could you do this? And if you can do this, you probably can do the other. It was really fascinating. I absolutely love to watch juries. That is why I am fingers crossed Joseph Duggar goes to trial. I want to be there for that one. Dr. Shaknovsky goes to trial. I want to be there for that one. We'll see what else comes up along the way. Yes. And especially for that case, for me, Kelly, I had followed that case from the beginning. So the people that were coming in and testifying, and the family and everything, I felt like I knew them because I had followed this case for so long. And that made it just like surreal that I would be sitting in front of me was Dan Markel's mother and father and sister. And leaving the courtroom, Harvey Adelson opens the door for me and holds it for me. What is happening? It was bizarre and a very, very surreal experience. So that case in particular, because I had followed it for so long, it's almost like they weren't real people to me. And then I'm sitting in a courtroom and they're real people, and I am there with these real people. So, yeah, this is Georgia mom, or they dislike their mother-in-law. That's possible too. I dislike Mr. Demeanor's mother-in-law. I don't like her. Oh boy. Alrighty, let's head back to court here. Sorry, I just went on a Donna Adelson little tangent there. Sorry.
I think we're all kind of aware of it. It seems like you've got some thoughts as well.
I think it's just because of the nature of this case. I think we're all on high alert as to how this case is going to proceed forward. That would give us a fair and impartial jury, right? So I think we're all on the same page as to that particular intention. It's now just a matter of how we're going to make that happen. So, having the jury of 100 potential people on a panel and individually hearing them might be a problem just because of the time issues here and constraints. I don't know what the court's position would be on that.
Sure. We won't be able to ask them their movies.
It's one of the best questions ever asked. I think that's true.
Anyway, I think what I see doing is when people raise their hands and they've heard about it, we'll ask that question individually, but not the entire voir dire, because I think, as I've seen, you pick a jury, you pick a jury. There's a lot of building that goes on the other questions, but the questions about the victim, if people know them, or people know this situation, I think need to be outside the presence. I agree with everybody.
Yes.
Okay. All right. So denied in part, or denied as to full sequestration, granted in part as to partial sequestration, which we can all work out a little closer.
Sound.
The
I'm
next
so
motion,
sorry, y'all.
Woo! Calendar would be the motion to suppress.
Your Honor, due to the fact that we filed a very lengthy motion to suppress in this matter, I'm going to rely on my notes and just let the court know. I don't know the last time I've done this voluntarily, so be in front of the court like this. But I think the issue here that we have with regards to what we filed is that the statements that were made by Mr. Davis in 2008 and 2009, we're arguing here that it's not an issue of immunity, which was covered before by previous counsel. This is an issue now as to voluntariness.
Right, and I did see that in the opposition. They were kind of arguing, this is what I think meant to Mr. Stanford arguing, but it seemed like you were focusing on voluntariness, so that's what you want to really focus on.
Right, because those are the things that have now been developed during our review of the discovery in the matter.
Okay.
And what we're talking specifically about are interviews that were conducted of people that were either present during the interviews with Mr. Davis in 2008 and or 2009, and with regards to Detective Mogg's efforts afterwards in terms of his interviews with people and what they believed to be something that they couldn't get into because of their knowledge of what was going on during that time period.
Okay, so then when we're talking voluntariness, first we're saying Miranda doesn't exist, or is this a custodial interrogation, and then we're moving into kind of these common factors.
Correct. Now, I think, and I want to make sure in terms of the motion that was filed by the state, the issue I think that we have here is that the position the state, I think, is taking is, okay, because Mr. Davis allegedly lied, that somehow the proffer does not cover. He does not have the benefit of the protection of the proffer because of the fact that allegedly he's lied in this matter. The issue that we have with that is that, first of all, we cite to Rogers v. Richmond, which is 365 U.S. 534, and this is on pages 543 to 544, that in essence, the Supreme Court has mentioned that, hey, the trial judge should focus on the question of whether or not the behavior of law enforcement officers was such to overbear a defendant's will to resist and bring about confessions not freely determined, and not necessarily because of the fact that they're, whether he lied or not. The idea behind it is that when an individual goes forward, he's in a room, he's with law enforcement, does he lie or not? It sort of doesn't matter. That's not the analysis here that was offered in Rogers. In addition to that, with regards to inconsistent statements or defenses, we can offer inconsistent defenses, which is, we cite here to Matthews v. U.S., and this is 485, U.S. 58, as well as U.S. v. Dema. And what I mean by that is that, we have, due process requires us as defense to have a meaningful opportunity to present every available defense, even if defenses tend to be contradictory to one another. And that happens all the time in cases where you say, well, we don't think he was here, but if he was here, he was acting in self-defense, something along those lines. And I think the court can understand that issue. To me, the other part of the problem here is the idea that, hey, we waive the privilege because it be voluntarily disclosed. The state points out NRS 4949385 to talk specifically about this idea of privileges and so forth, but the problem is that the privileges aren't applicable in this particular case. It's not a privilege in terms of, say, attorney and client. This is an individual who's in a room with other people. And so with regards to the analysis under 49, NRS 49.385, it's an inapplicable argument because it doesn't apply to this particular scenario and fact base. In fact, I think the interesting thing about this case for everyone that's concerned is that there's a lot of ideas here that may end up being things of first impression. I mean, trying to find case law that fits and provides some type of direction on this particular issue it's not out there. There's no case on point. There's no issue with regard to the Supreme Court, the United States or Nevada, that really sort of lent any type of real direction to the court to follow. I think at the end of the day, one of the things here is comparing what they're arguing to Diaz versus 8th Judicial District Court, which is 116 Nevada 88. The Nevada Supreme Court held that the waiver statute does not apply privilege in that particular case with regard to news shield statutes. And that was a case in which a journalist does not have to waive any rights or privileges by publication if they do publish. And so as a result, we're also arguing that it's the only direction that we have right now with regards to how the Nevada Supreme Court has viewed that particular issue. No Nevada Supreme Court or U.S. Supreme Court cases directly address the proffer issue with regard to a promise or inducement to render a confession involuntary. The voluntariness of confession is determined by the totality of circumstances. I cite to Arizona v. Fulminante, which is 499 U.S. 279, and I'm going to quote to it. It says, "A defendant's confession is like no other evidence. It is probably the most probative and damaging evidence that could be admitted against them. And if it is a full confession, a jury may be tempted to rely on it alone in reaching its decision, while some statements by a defendant may concern isolated aspects of the crime or may be incriminating only when linked to other evidence. A full confession, in which the defendant discloses the motive for and means of the crime, may tempt the jury to rely upon that evidence alone in reaching its decision." There should be a huge red flag of extreme caution to the court with regards to admitting that kind of information from 2008 to 2009. And that is, once again, Arizona v. Fulminante 499 U.S. 279. We have a situation here where it's a 30-year-old case, it's a multi-jurisdictional case. There's a lot of things that were done in secret, and it's messy. The question is, at the end of the day, whose fault is that? Obviously, we're not law enforcement, we're the defense. Mr. Davis is a citizen wandering around in his life doing his thing. And in the meantime, as this is happening behind the scenes and under the table and in the water, there's movement, planning, things that are happening, discussions that are taking place to try to figure out, okay, how do we resolve this issue? And the problem is that if we keep Mr. Davis as someone that's responsible for this, for the messiness of this case, for that kind of thing, I think we have a huge issue, because I don't think it's his responsibility. We focused a little bit on this idea of, during the course of the time that he's meeting with these people, is that they threatened him. I don't know if the court received the thumb drives with the audio. Did you get a chance to review it? Okay. We gave that to the state as well. But with regard to the communication that's happening during this time period, it's pretty clear that Mr. Davis is being threatened.
Sorry, I put it up a notch on the speed. I'm putting it on misdemeanor speed. Sorry, because I'm just like, it's a lot of words and I don't feel like he's saying much. So sorry, you can slow me down, or I've got the closed caption up. So
there's an understanding here during the time period that while he's in.
Are you referring to the Los Angeles or the Las Vegas? Or second?
So the 2008 would be the proffer that did not include Las Vegas Metropolitan Police. The 2009 is the meeting that Las Vegas had come down.
So when you're talking about threats, are you referring to Detective Kading in 2008?
This would be the 2008.
Okay.
And Detective Kading is the one who mentions that, who talks specifically about it. And so let me just go through that part as well. The idea of Detective Kading, I think, is another problem. Now, Detective Kading, according to what the state has filed in their opposition, is that he's a private citizen, which I don't know. Maybe that was mistyped. It's pretty clear, Detective. You give me a look. Is that because
No, you're fine.
I think at the end of the day that the idea of Detective Kading being a private citizen somehow, and once again, this is in their motion. This is page 18. They say the following: Nevada exercised no coercive police activity against defendant in connection to the 2008 proffer. No Nevada officer interrogated him. No Nevada officer threatened him. No Nevada officer made any promise to him. The cating assurance came from a federal task force detective operating under a federal proper arrangement to which Nevada was not a party. Connolly, which is the case that we cite here, that they cite, forecloses the defense's claim regardless of how the Basama factor analysis is framed, because the constitutional predicate for finding of involuntariness is entirely absent from this record. The only violation of his agreement was not by the government, but by a private citizen. And the only private citizen that we know that actually disclosed what happened in the 2008 meeting prior to a publication of a book or an interview done on a podcast or series was Detective Keffe. And so, in essence, if that's what we're talking about here, maybe what they're saying is something else, but to me, the idea of a private citizen, if that's referring back to Detective Keffe or anybody else for that matter, I think that that's erroneous. The law with regards to HAC, which is what the state has relied on in their opposition, it's under the Second Circuit, it's 884 F3rd 400. It's not binding legal authority. Now, it is still distinguishable in this case because even though HAC, the defendant in that case, was not in custody, detectives advised them of his Miranda. If you look at our case as a whole in totality, there's no proof at all. There's no recording, there's no discussion about Mr. Davis ever being Mirandized prior to giving any statement at all. See, but that's the problem with the analysis in terms of him being free to leave. If the analysis is he could have just walked in and said, hey guys, and then do whatever, walk out, sure. But
then it wouldn't have helped with his other situations. So
correct. So now you have that problem of, hey, you leave, we're just going to arrest you on a drug charge, and we're going to arrest all your entire family, we're going to arrest everyone that's involved in this, and then now here you are. So, was he free to leave? No.
Correct, but he's also got this attorney, which, as we know from, law and order, it's the second one they say, that you have the right attorney silent, and you have the right to an attorney. He has that attorney there, so it's not really this naive big what where who can be overcome by these coercive techniques of the officers.
Yeah, but at the same time, though, once again, like I could have been sitting next to Mr. Davis back in 2008, and if I know at that particular point what's on the table is if you leave the room, we're going to arrest you for drugs. What's my advice to my client? I mean, to me, at that particular point, it's like, hey, man, you got to do what's best for you and your family. You choose your path and where you want to go. And so, as a result, once again, is that custodial? I think it is, because in essence, he cannot leave because the threat is, you leave, we charge you and your entire family for drugs. That would be our position on that.
Hey, here's an idea. Don't break the law. Just saying. It's an option. It's a choice that could have been made, but that's not the choice that was made. So now you've kind of made this mess and you got to sit in it. I like this judge a lot. Another female judge. Woo, woo, go women. Woohoo.
Now, in addition to that, the other case that was cited by the state is Colorado v. Conley, which is 107 Supreme Court 515. The Supreme Court there held that, first of all, number one, a coercive police activity is a necessary predicate to determine whether a confession is not voluntary. Two, that the statements made by the defendant when he approached police and stated he wanted to confess to a murder and then did so after receiving his Miranda could be admitted without violation of due process because of his mental health. And then three, whether or not the state bears the burden of proof in a motion to suppress a statement already obtained by violation of the Miranda doctrine. The state only needs to provide proof waiver by preponderance of the evidence. Now, it still doesn't fit the fact pattern in this case. That's why we're going back to the first problem, which is there's no precedence. There's nothing here to sort of say, hey, we have a framework, we have a previous situation that we can sort of use as direction in this particular case. In addition to that is that, in Conley, for instance, Miranda still was given. So even though it may have been late, even though the defendant in that case sort of admitted to the crime 5 minutes before being Mirandized, Miranda was a big part of the court's analysis in that particular case as well. So yes, even though a client might be sitting next to an attorney in the middle of a meeting, the process of the Miranda still takes place. There is still an advisement of the person that, hey, we're going to have a conversation here, and it might be against your interests. Now, is it up to the defense attorney to lean over? By the way, hey, you got a right to remain silent. No, it's the responsibility of the law enforcement officers in that room to give that announcement to the client, which in this case didn't happen. And it goes back again to this idea of just being sort of like.
Well, he's not their client. He's the client of their attorney.
Oh no, I'm sorry. Maybe I rephrased that wrong. But they're in there specifically for one purpose and intention. There should have been at least the idea of a Miranda. I don't know if this or not, but so on YouTube, I get a lot of YouTube reviews now. One of the YouTube things I look at, for some reason, the algorithms give me this, is police arrests, for some reason. And every single time, they will immediately default back to the Miranda. Why? Because they need to cover that basis. Even if it's premature, whatever the case is, they want to make sure that whatever's going to happen here does not violate that Miranda right. And I think in this particular regard, you had some very educated people in that room. You had FBI, you had DEA, you had Compton Police, you had LAPD, you had a United States Attorney allegedly in that room as well. And those people should have at least pointed and say, hey, just to cover all of our bases, let's just make sure this happened, and it didn't happen.
And in your research, you have not been able to find a similar situation where this situation.
Here's the best part about this. Yes, and here's the best part about this. At the end of the day, this is going to be a case that more than likely will be whatever is going to happen at the end of the day. This will be sort of that case. It will end up being the case in which the extent of how Miranda is used and the idea of when someone's...
Or won't, so we have to make this decision when this trial is like.
Oh, of course, absolutely. But I'm just saying at the end of the day, with regards to this particular question would be the driving question here. If it does end up having to be revisited by an appellate court in the future.
Sure.
I just think that when we have a situation where you have multiple times MOG interviewing different people and everyone agreeing that, hey, yeah, we can't touch this, we can't get into this, we can't discuss this. Kading in the interview of this 2008 interrupts and says basically to Mr. Davis, what is said right here cannot be used against you, Keffe. Nothing you say today can be used against you, so don't even worry about it. And this is in a room with all these other detectives and people that at least at some point somebody should have said, no, we're going to run into a problem. Nothing.
Sir, do you honestly think that Keffe D didn't know that he had the option to keep his trap shut? You think he didn't know that he had the option to walk right up out of there? Of course he did. Did you think that Keffe D thought the police were always going to be perfectly honest with him? No, they can lie. He knows that. He is not some shrinking violet that doesn't understand law enforcement in our legal system, and certainly not back then in 08 and 09 when they were talking about this. Was he a shrinking violet? Let's be real here. This is not a 17-year-old being interrogated without their parents present. Give me a break. Come on.
Something like that happens in this case. We also identify in the recording as well, that it was a discussion here with Detective Long. And his idea of this is like, he said, this is like an informal meeting. He's trying to get information. This is Higgins talking to the defendant. Now, once again, would I have said something like that? But people are telling my client, hey, this is not a big deal. We just want to get information. And Long says in his discussion directly with Davis, you understand that? All I want to gather is some information. I have absolutely no intent of arresting you today.
Today?
When things are happening here and then all of a sudden it's clear on the recording.
It might not have been his intention that day or even when he said it, but if something comes up in that conversation, he can very quickly change his mind and his intent can be something very different. Sir, you're not that dumb.
That Mr. Davis is uncomfortable with the line of questioning and he wants to have a conversation. For some reason, we still have the recording take place as there's a confidential conversation between the attorney and his client. But in that, Mr. Davis asks the question, can I talk to D-Boy, meaning to Dupree? Detective Long steps out. And then Dupree says, hey, yeah, you know what? Whatever you told us, it will stay consistent with what you told us. And then he basically says, look, I need for it to stay with it. Meaning I need to stay with what the agreement was. Everyone is under this impression. And the problem is, though, this is coming from interviews that are conducted with these officers after the fact. When Davis later says, I say whatever I tell them. The problem is, though, is that it's pretty clear that Mr. Davis is not comfortable with with being in the situation. He's not clear as to what's going on. And the question then is asked, is it the defense attorney's fault? Or is it the law enforcement officers who should be saying, hey, I want to make sure we're clear here, Mirandize this man, or inform, let him know what's going on with his case. When you listen to the recordings again, it says, over and over again, it's like, the question is it confidential covered, right? Yeah, and they said you cannot be charged on it. There's conversations between Mr. Davis and his attorney. Later on, when Detective Mogg interviews, he says that, that Detective Dan Long came down to the area, and in his speaking with Mr. Kading, he said, Dan Long came down and interviewed Davis under this proffer, so none of the stuff can I use in any way, shape, or form. So Detective Mogg at some point starts saying, okay, I also can't use any of this stuff, and it's not like he's getting a lot of pushback from anybody. Kading responds in his interview with Mogg and says, with the proffer, everyone understood it was a proffer agreement. Everyone understood it was a proffer. He says this was a verbal agreement between Higgins, who is now dead, and Tim Seawright, who was the United States attorney that was present in that meeting. 4 investigators sat in on the multiple proffer sessions or interviews with his attorney, with Davis's attorney, and everybody understood it to be a proffer. The Mogg continues to ask questions, and it's clear that Mogg's understanding of what's going on is based on the idea when he later says, and this is in the recording again between Mogg and Detective Kading, everyone thought initially this was a written proffer agreement, but now it's even more afraid than anything I could have imagined. There's no way, because they can bring that into court and that would get suppressed. That's Detective Mogg talking to Detective Kading. Detective Kading responds to that statement and says, from a prosecution standpoint, you kind of go into this knowing the proffer would be suppressed. Anyways, just on the nature, that's the purpose of a proffer, is to not use it. So even if they suppressed it, I wouldn't imagine they're going to try to use it anyways. And then Detective Mogg responds and says, my whole thing is to try and put the whole case together without any of the information that could even have been remotely connected to the proffer, to which Kading responds with a agreed. Now, one of the questions I think that's been asked here is why would he give a proffer? Why would Mr. Davis have this conversation? Detective Kading explains it to Detective Mogg and says, the beginning of this whole thing with Davis and how we're trying to set him up was, we developed Dirt Rog as an informant. We began buying kilos and PCP until we could meet the threshold that the United States Attorney wanted for a minimum mandatory sentencing. We wanted to get as much leverage as we could, which would have been a life case for narcotics based upon his prior convictions, and so that's what we did. We just started to work up the dope case and got to the threshold that Tim Seawright, once again the United States Attorney, wanted, and then approached KPD and said, here's the deal. I don't know that's involuntary. When you have Detective Kading, who's present, who's there, who's meeting and having a very private conversation with Detective Mogg and is explaining things the way he recalls it, that's not voluntary.
So that's 2008.
Yes.
Another statement, 2009.
Yes, I'll get to the 2009 letter. This is like a 40-page motion that,
40 pages? Every page?
you know, I'm just billing per the hour, and so I think every page is at least 5 hours.
You can do whatever you want. I'm just curious as to, I completely understand. Like, listen, you're saying, you hear the beginning of the statement. Law enforcement says, this isn't going to be used against you in any way. And now they're saying, listen, let the jury hear it. I get that. I get how the difficulty there. Now we're in 2009. We're into this, and that's a situation I know Las Vegas doesn't have necessarily any proper contract between two parties, and Vegas is one of the parties. So it's a contract that doesn't necessarily exist with that involved in it. However, now we're talking about 2009 and how do we get there?
So I think the problem is that when you look at it from the viewpoint of, I mean, did Compton and LAPD really hate Las Vegas Metro to the point where they just weren't going to disclose any of this information? That they wouldn't have said, hey, we met with this man is saying that he knew some information about the murder of Tupac Shakur, and as a result, this is what's going on, that somehow they just kept all of that from Metro? I don't know. Because to me, the inaction of what happens next is the problem. 2008, there's no movement by the Clark County District Attorney's Office, which would indicate to me one of two things. Either they didn't know about the proffer, or an alternative, they knew about the proffer and chose not to do anything about it because of what you're seeing now from all these different people that Detective Mogg had interviewed, and that is, it's a proffer, we're going to stay away from it. Now here's the thing. Say it's the second problem, and the second problem is they weren't notified. 2009 comes along, and what happens? Las Vegas Metro goes and interviews with Mr. Davis. They are no longer in the position where they can say, hey, we didn't know anything about this. They're meeting with Mr. Davis, they sit down with him, he gives a statement, he answers their questions, and they leave. What happens after that in terms of the Clark County District Attorney's Office? Nothing. If there was this discussion and disagreement, that, hey guys, that was your agreement, the proffer was between your parties, between the state of California and the federal government and Compton and LAPD, that would have worked for 2008. But what happens in 2009? So to me, when you hear what these attorneys or these investigators and detectives are talking about, is that there was an understanding that, hey, that covered it. Now, why would a detective go down and speak with this individual in 2009? To ask questions and clean up the file. To follow up on loose leads, to figure out where everyone was at or do whatever the case was in this particular case. That's why you would do it. Not to go down there and see if you can arrest the guy, but rather to say, hey, you know what? He's got the information. Let's finish up this file.
As far as this being a setup, yeah, absolutely. Our law enforcement does this all the time. They have undercover detectives and police officers that act as prostitutes and sex workers and drug dealers and all kinds of nefarious activities, strictly so they can obtain enough criminal activity and evidence to be able to move a case. So that does not surprise me in the least. He clearly wasn't concerned about getting caught with any of those things because it kept doing it. So I can only have so much sympathy. If you're going to lay with the dogs, there's going to be a really good possibility you're going to get some fleas. So that's where we kind of are here. And I get the, hey, nothing you say can be held against you. Well, you're a dummy if you think they actually meant that when they said that to you. You're a fool. Come on. Excuse me. It kind of came out of nowhere. You are a fool if you think you can say whatever you want to law enforcement and that law enforcement tells you, oh, we're not going to hold this against you. No, we just need to get some information. Yeah. You're probably in an interrogation room and you're probably being recorded. Trust me, it's going to be held against you. And if you're not in an interrogation room, there's real good possibility they've got you on a body camera. Guess what? It's going to be held against you. That argument does not fly for me. I'm sorry.
To me, the 2009 Mogg is the one who really talks and really sort of indicates this. He says, he told Detective Ladd, we even sent the detective out here in 2009 who interviewed Davis with his attorney, and the LA detectives told me that, yeah, everybody was under the impression that that was still under this proffer, so I can't use any of it. What does that mean? Detective Mogg takes over the case in 2017. He knew about this particular person going down and meeting with Mr. Davis in 2009, and even he believed at that particular point that the proffer still covered whatever the interview was between Detective Long and my client.
Here's the sad part, Debbie. He did lawyer up. His lawyer was sitting there with him. So not only was Keffe dumb about it, but his lawyer was dumb too. His lawyer should have said, shut up. Let's leave. Let's deal with the drug charges. We can try to plea you down to something so you won't spend life. But right now, you can't have it both ways, sir.
So that's the 2009 issue. Once again, we just believe that the statements made at the time of the meeting 2008 and 2009 were involuntary. It's not a matter of this immunity issue. I think it goes more fundamental to that. And that is, when you're given a statement like this, you're forced into a position because you're afraid of the consequences of saying no. And the consequences of what was happening here wasn't necessarily because Mr. Davis was afraid for himself, but rather the threats that were made against his family and his friends that was built up over time. Detective Kading agreed to that and said, yeah, we built up this case and we got him to a position. Now, when he's talking about building up to the sentencing guidelines, in the federal system, there are mandatory minimum sentences, and you have to accumulate over time. There's an objection you can make as a defense attorney. It's called sentencing enhancement. You basically wait until the amounts that are accumulating gets to a mandatory minimum 10 years, whatever the case is. That's what he's talking about. So they literally just sat and waited, and they just accumulated more and more information until they got Mr. Davis in a position where he was afraid, like I said, not only just for himself, but for his family. And that's our position with regards to the 2008 and 2009. I hope I did my motion justice. But with regards to the last issue, and that is the Compton, the book.
The book. Oh, boy, the book. Oh, Keffe.
What's interesting about the discovery that we received in this case is that we received an interview that Detective Mogg, I guess it's Mr. Mogg now, had done just recently. I want to say it was in the last, 4 weeks, 5 weeks, something like that, where the individual that's named in the book next to Keffe D, or Duane Davis, Keffe D is what is on the cover of the book, is this person named Yusuf. The interesting thing about that is because Detective Mogg, for some reason, never made an effort to interview this person prior to submitting this case to the grand jury in 2023. Which you would think is sort of common practice, it's sort of commonsensical, it's what you would do because you got a name on a book and then you also got another name as somebody who also wrote the book. And as a result, you've got two different people on there. Why not interview both people before reading the book into the record? Because it's not like he testified and said, this is what I do, and the book was part of it. He read excerpts of the book as if it was the gospel truth into the record on the grand jury. And so our position is that in this particular case is that, look, he finally goes and meets with the other writer, but the writer's not giving him the information that he wants. He's not saying, hey, I just received whatever Mr. Davis sent to me on an email. I just put it in the book. Whenever I did something wrong, he would correct me. It's not that conversation at all. What the conversation is about is like, hey, it's this idea that, hey, in the book, He sort of made it up. And I'm not talking about Mr. Davis. I'm talking about this other person named Yusuf. So to me,
Well, I mean, doesn't that disregard every single promotion of that book?
you know what the problem with the promotions are?
Yeah.
You don't raise your hand to tell the truth, the whole truth, and nothing but the truth when you give your promotion. You don't sit there at, in BT in the middle of this, 6-part documentary and you say, you know what, I'm going to tell the truth today. Now, you do expect to tell the truth, and what people do expect is that when you're questioned by law enforcement, that you are telling the truth when you're being asked questions about some investigation, right? There's an inference there that you are going to tell the truth there. But to a documentary, in a promotion of a book, to me, the problem with the analysis is on some levels that we're putting way too much credence and value and weight on statements that are made for entertainment purposes only. Not a confession to a priest, not a confession to a police officer, but rather to promote a book, to sell a product. And that's where we're at with it.
I think you used a really interesting word when you said the weight to give this, right? I mean, I don't know that there's necessarily a legal basis to keep this out, to keep the book out entirely, or admissibility. I think all of your arguments that you've argued about Mr. Duca and how this book was written and how it was composed, maybe you got to weight. What weight the jury should assign it as opposed to a legal admissibility issue.
Yes, Sean.
Okay.
And I think ultimately, just with regards to the motion, we do label out other parts of it, and just to get to the point at the end, once again, I think we have a huge problem here if we're going to say.
What just happened? Can anyone fill me in on what just happened? I thought he was arguing a motion about why to keep the book out and anything about the book. Am I tripping? Did I take a little vacation away from this little hearing here? Because she said, well, I think that goes to the weight and that will be something the jury will need to consider. And he said, exactly. What? Sir, I'm trying to follow you. I swear I'm trying to follow whatever it is that you're saying. But, by the way, I just noticed this unbelievably amazing little bobblehead on Your Honor's court desk. Oh, my, I am loving it. I'm loving this. All right, let's move on.
Hey, look, his words in 2008, 2009, even based upon what these other detectives were saying that were present, people who understood what was going on during that time period, that this was a proper, all those things, I think on some level, all of a sudden now the state wants to say, well, we weren't party to that. But you were party in 2009. And on top of it, too, it's law enforcement. I don't understand how that wouldn't be a thing with regard to each state honoring the efforts of other law enforcement with regard to their investigation, even if it's about the same thing. Maybe that's another issue that will go up on appeal, and that would be a different issue that would be decided with regards to new case law. I don't know. I just know at the end of the day, what we have here is we have an individual that gave an involuntary confession, who gave an involuntary statement because he was threatened. It's clear from the record, it's clear from the interviews with these previous detectives that was the issue, especially from Detective Keating, and as a result, we will be asking the court to suppress the 2008 and 2009 interviews and the book.
Okay.
Oh, and the book again.
Turning to the state.
Okay, here's the problem with that, for me anyway, and y'all know, I'm just your jury 4 person, so I have no legal education whatsoever. But just watching this in layman's terms, the issue is this, supposedly he was being threatened. I don't think that was a threat. I think they were telling him what their plan was. Sir, we have this and this and this and this on you. And sir, if you should leave today, we're going to take care of this and this and this and this that we have on you. I don't necessarily know that that was a threat. I think that was more like, this is what we're going to do. We're going to give you an option. I don't know that that's a threat. It's kind of like when my son was younger and I would say, you can do this or you can do this. And looking at the choices, neither one of them was great, but you got to make a choice. That's kind of where Keffe D was. Neither one of them is great. Got to make a choice.
It's the voluntariness argument. I think the voluntariness framework is what was really raised here. And I think the issue is sort of morphed into that of essentially when you're told this will never be used against you, that's very coercive, and that's essentially renders it involuntary. But that really wouldn't potentially apply to the 2008. Did you want to be heard about all of the issues that Mr. Sanchez brought up?
Yeah, and just briefly, because obviously the book is admissible in a number of the topics mentioned, but I also think they're taking a lot of liberties with what the author said about the book. But the book is central to almost every other argument.
So you start with the book and work backwards?
Yes. If you notice, and I don't know if the court's read the entire book, we've given
I read these
segments of it before. And maybe we should supply the court an entire copy of the book because you'll have a better understanding of all of the facts that are discussed within that book.
Now I want to read the book.
How the trial will proceed and questions. We were actually going to file a motion in limine on what portions of the book the court is going to admit or not admit, although it becomes...
Was it a motion in
when the
limine
defendant
or
is gonna
motion in
disclaim
limines?
Authorship of the book, we should be able to establish every fact he says in there, but there are some very prejudicial things that he says within there that are true, but maybe more prejudicial than appropriate. But that being said, this issue is, right now, the authentication, I guess, is really what they're arguing. And obviously, as the court notes, he adopted it by admission, whether he wrote it or not. So, to me, the 2009 aspect, or sorry, the 2018 book, 19 book, really isn't in dispute here. The court's already sort of assessed the 2009 one, and I know that Mr. Samp said, well, what did the DAs know or not know back in 2009, and that should somehow be held against us. But the court, in the motion for immunity, reviewed, I didn't put Dan Long's affidavit, but also I did put Detective Long's affidavit in here. In 2009, nobody from Las Vegas could understand the circumstances of that situation. And look, I don't know if you need me to address police officers aren't lawyers, but clearly police officers aren't lawyers, but might there have been a reason for Detective Mogg to have investigated this case without ever reviewing the 2009 case statement? The grand jury presentment being done without the 2009 statement because at the time, we still didn't know what the circumstances were, and ultimately, we now do know what the circumstances are. And the only thing that matters is what Mr. Davis understood when he was in that room. And the only person who knows the situation in that room as to exactly the legal consequences of his conversation is the guy who negotiated the agreement with the federal government in 2008, Wayne Davis. And if you read the transcript, you will see that Mr. Davis makes no inculpatory admission sufficient to charge him with a conspiracy in the crime. And when Detective Long begins to ask him questions about that, Mr. Davis asks to have a meeting, and I know Mr. Sam said, I don't know why they were still recording, but there's still a cop in the room while that conversation is going on. So it's not privileged communication. And what the lawyer tells him is, hey, you got to be a little fuzzy on some of these facts because that guy out there wants to put a case on you. He can arrest you for murder. So
there was a police officer in there when this recorded conversation that he tried to make it sound like it was client attorney privileged conversation. Sir, don't lie. Don't lie. That does not go well. That, ooh. This is why defense attorneys get bad names and people think they're slimy. It's because they do things like this. You can't just say something that is absolutely not true.
you can't be telling him specifics. And Detective Dupree says, but you can't lie, because that'll vitiate your agreement with the federal government. And so Davis makes the decision to talk to Dan Long.
Makes a choice.
Why he made that decision or not isn't the issue. The issue that they're raising is voluntariness. He's not in custody. No promise has been made to him concerning that statement, and he clearly understands that the statements being made against him are going to subject him to a criminal prosecution for murder, and he's being told that by his lawyer. So 2009 is obviously admissible. Now you get to 2008. And look, your initial reaction from the content of the conversation in 2008 is, this shouldn't be admissible. But then you ask yourself legally, why isn't it admissible? So, voluntariness.
My knee-jerk reaction is because Detective Hayden goes out and says, this won't ever be used against you in any way, Keffe.
Correct. But that doesn't make the statement involuntary unless the promise is broken, and then there is still an analysis. And
Let's talk about the broken promise.
Yes.
Because that's a bit of a,
Right.
an interesting needle you're trying to thread here.
And I was going to get to that,
Okay.
right? And it's because Mr. Santa asked, why didn't we do anything in 2009? Well, we also didn't do anything in 2011 when former Detective Kading writes this book, right? We didn't use it against Mr. Davis in 2000.
Detective Kading wrote a book too. See, I am so behind on this particular case, and I'm kind of glad because y'all know I like to go into trials with just having kind of a framework. I don't necessarily want to know all of the details of the evidence because I want it to kind of unfold in front of my eyes as a regular juror would. But what? Former Detective Kading wrote a book? Oh, I'm going to have to look it up. Exactly, Debbie. The police can't make promises, but they sometimes make you feel they can. I completely agree. That's where Keffe D was wrong and his attorney. But let's see what this is. I understand if they said none of this will be held against you, and then they did hold it against him. So let's see what happens here.
2011, or when the tape is released later on that year to the documentary done by Mike Dorsey. That statement is that we didn't go, oh, we're going to run down here, we're going to arrest you, we're going to use the 2008 statement. That didn't happen either. But from a legal analysis, his argument is it's involuntary, Judge, not that a promise was broken in a contract. He's arguing that it's involuntary, that essentially saying that there was some sort of coercion to him. He got arrested and was subject to prosecution for a life sentence from the federal government for PCP and a kilo of cocaine. He is also subject to prosecution by the LA County District Attorney's Office for PCP and a kilo of cocaine. And he's a third strike in California, so he's looking at a life sentence. And as he explains in his book, as you've read, he has to make a decision as to whether or not I want to talk to these guys or I want to fight the charges, and I knew they had me on the charges. So he explains in his book the voluntariness of his decision to have this conversation. And at the time, the police actually think he's responsible for the Christopher Wallace murder. They are not there to interview him about Tupac. It's during that first meeting that he tells them, hey, I know something about Tupac, and then they're...
Christopher Wallace, by the way, does everybody in the chat know who Christopher Wallace is? You let me know if you know in the chat. I'll give you a minute or two.
There is the second meeting that there is a recording of from December 2018. That may be covered by some agreement between the federal government, the LAPD, and Mr. Davis, to which he can, by contract law, hold them liable for. The fact that Greg Kading, and that's why I say as a private citizen, later on released it to the public, is something that agreed to everybody who does this for a living, is something that just is it seems unfair to utilize it against them. Did you agree? And I think everybody in 2011 felt that way as well. But now you have to look at what the factual scenario is now. Imagine, if you will, that a defendant goes into a police station and he gives a statement to the police, and that gets suppressed, that's highly detailed about his involvement in a murder. And the court suppresses it. And the defendant walks outside the door and says, everything I said to the police is absolutely true, but because the police screwed up, the statement is suppressed against me. Wouldn't
Y'all don't know Christopher Wallace? It's Biggie Smalls. Yeah. Biggie Smalls' real name was Christopher Wallace. So that's who they brought him in to discuss everything about the case and not about Tupac. So that's why he was all like, oh yeah, sure, and all that. So is it starting to make a little more sense now?
we be able to charge him with everything he told the police was true, and then use the statement to establish the context of everything I told the police was true? 100% we would. And so in 2019, when the defendant decides himself to write a book where he describes a factual scenario all the way through conversations he had with his lawyer, all the way through the decision making that went on in his mind, all the way through the fact that he gave a truthful statement, and then all the way through the fact that he is so mad at Greg Kading for doing him dirty and by releasing it and demanding consequences for him, at that point, when he says I told them the truth, it's the same as the defendant who walked outside the door with an inadmissible statement. Whether or not it's admissible in 2011 is irrelevant to your analysis. He adopts it in 2019 in a book. He himself adopts it. Yeah, we put some waiver arguments in there and everything else, and their position on the book is it's fiction. So we should be entitled to establish what he said in that book is true. He did wind up meeting with his
this
lawyer.
attorney.
The cops did go to his garage and explain to him, hey, we've got you on all these. Your brother Kevin, we got him on it. The other person that they mentioned that he got, everything he says in that book is 100% true. And then he does go down to his lawyer's office, and the court can't possibly find that a proffer situation is inherently involuntary. You'll be saying every proffer is inherently involuntary. What you're saying is that there was not a promise followed. But we're not relying upon Greg Kading's releasing of this information in any way, shape, or form. Had Mr. Davis never opened his mouth, had he never decided to take money and go on BET and talk about this situation, had he decided to never write the book, he would not probably have ever been prosecuted for the crime.
Absolutely.
But once he decides to write that book in 2019 and describe this situation, we are entitled to prove up what he's saying is true, including what he says about the facts, the Lakewood Mall incident, the MGM incident, the shooting incident, the aftermath. Everything in there is now admissible because he chose to release it to the public. He chose to profit off of it. And therefore, whether or not Greg Kading violated the promise when he was a private citizen, it didn't change his agreement with the federal government. He becomes a confidential informant in March of 2009. He does these trips. None of that is covered by any sort of proffer agreement. What he's doing is, what the court knows, and I know Mr. Samp knows, in federal court, he's trying to provide substantial assistance to law enforcement. Because he can either get a no prosecution on his PCP or his cocaine, or he can get a 5K departure on whatever sentence he ultimately gets from any prosecution that occurs from it. He's not promised no prosecution for the PCP within that proffer that you see. Tim Seawright says, I only gave him a proffer letter for one occasion. We're willing to accept that multiple proffers are acceptable. But at the end of the day, nothing about what Greg Kading did retroactively makes this an involuntary statement.
How do you intend to use the 2008?
I intend to establish the factual scenarios that he provides in his book. And what he says is, my lawyer told me not to lie, so I didn't lie. And I told them the whole truth about Tupac. I had nothing to do with Biggie. And then I planned to actually play the recording of him saying exactly what happened, which is consistent with 2009, and then consistent with there's been no motion to exclude the fact of a proffer, nor the fact that he becomes a confidential informant, he flies to New York, he meets with Zip, which corroborates the fact that he knows Zip. There's a conversation where he tries to set Zip up on a drug deal. All of that, none of that's covered by the proffer in any way. The sole issue for the court is somehow Detective Kading in 2011, when he's a private citizen and decides to make money off something that was a confidential document of the task force, is released. But that fact is irrelevant to the analysis of the court on admissibility, particularly since in 2019, the defendant describes the entire situation himself, and he does to a certain extent in 2017 on those recordings with BET.
Okay. Mr. Shanks, anything further?
Yes, Your Honor. Just a couple things just in response. I think the court's first initial impression upon reading and seeing the evidence that's been presented to the court is the right. It does shock the conscience on some level when you have openly a discussion with a detective who says, yeah, we promised him we were going to prosecute him. And all of a sudden here we are now arguing and saying either we're not privy to that, we're not party to that, or in the alternative that my client sort of waived some type of protection, which doesn't make any sense to me either. I think it shocks the conscience. It's one of those things where you look back and take a step back and go, what? Like, you promised a man this and then you turn around and do this later. The other part of it too.
What do you all think in the chat? Because I understand the whole we're not going to prosecute you, but that doesn't then mean you get to walk around the rest of your life and anything that you say about it in perpetuity can't be used against you. If what you end up saying after the fact corroborates what you said in this conversation that you were told you couldn't be prosecuted for, like how do we reconcile that? Is it forever, never can be the truth and can never be held against you, even if you say it again some other time? I don't know that I'm okay with that. I don't know that I'm okay with that. And I kind of feel like that's the primrose path that Mr. Grateful Dead attorney Grateful Dead, I should say, is trying to get me to honor, or I don't understand. Yeah, Kelly, keep your trap shut. You're right. I don't know why. Why is everybody going to talk about everything? Go see a therapist.
Once again, going back to this idea of voluntary confessions under Arizona v. Fulminante, it's extreme caution. There's a danger here that if we do something like this, give this information to the jury, that they will turn around and say, well, so we just had his confession. His lawyer stood next to him. He, had every opportunity to talk to his lawyer, blah, 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 blah. But what we have instead is we don't have Miranda, we don't have any of the other things that would signal to Mr. Davis at the time that he's making the statements, that this is not one of those things where you just, frolicking through the tulips and at the end of the day, he's going to be okay. We are now in a position
Okay,
where
Tiny
we're saying,
Tim.
look, we want the confession to come in. The problem with the
Tiptoeing through the
confession, once
tulips
again,
now.
It sort of puts us in a bad spot. Now, the question that the court might have in your mind is, what's the alternative? Well, the alternative
Attorney
is
Tiny
other
Tim.
evidence that the state has that they're going to present to say that, he's the guy that's there and he's the guy that's in the car and, whatever it is they want to use. But regarding this particular request, this doesn't knock the case out. All it does is it says, hey, this is too prejudicial. That the probative value of the 2008 is far exceeded by the prejudicial effect of this case. And if we look at it from that viewpoint, we stay away from it. We don't get involved in it. We don't try to traipse in the middle. We don't clean up the mess that was made by other people in 2008. What we do instead, we say, look, we're going to move that off to the side, let the jury consider all the other evidence in the case to make their decision at the end of the day as to whether or not the state's met its burden beyond the bell. And so as a result, like I said, I think we have to have extreme caution with regards to the statements that were made in 2008. And I think it would be, the most prudent position would be to exclude the 2008-2009 statement.
All right, starting backwards. I think really no question on Council Street over the book. I find that as admissible under NRS 51.035 subsection 3. It's clear that Mr. Davis adopted the statements therein as his own through publication, promotion, and subsequent ratification. In his interview to the Live TV, he promotes this book as his book. He encourages people to buy it, get the real truth, and not from the law enforcement or industry people. He also repeatedly says it's something like the whole truth of the situation. So he's indicated to a reporter also on 10/21/23 that he wrote the book to let people know his truth. He's adopted its contents under NRS 51.035 subsection 3B. And then ultimately, when you look at the entirety of Mr. Shaw's interview, it supports that the factual content from the book was from Mr. Davis, and that Mr. Davis ultimately also got a manuscript and made no edits to the description of the murder that's relevant for today. Ultimately, the arguments regarding what Mr. Shaw's contributions to the book are, etc., goes to await non-admissibility of the book. I really find there is no legal argument to exclude the book.
That's not good.
I'm looking at what's in front of me. The motion is on voluntariness here, right? And so when I'm looking at voluntariness, I started this out saying, first I'm looking for is Miranda required, and then I'm looking to those Basama factors. And so ultimately, a criminal defendant is deprived of due process of the conviction is based upon an involuntary confession, and voluntariness is determined under the totality of the circumstances, including the age, intelligence, custodial status, and whether coercive police tactics overboard the will. When I look at Basama, Dewey versus State, and then the Miranda decision itself. When we're looking at Miranda, it's only custodial interrogation. It doesn't require warning for a defendant voluntarily providing information in a non-custodial setting. Statements offered against a party are admissible where they are the party's own statements or the party's manifest in adoption or belief in their truth. Neither required Miranda because neither ultimately were in a custody status, a setting. He was free to leave at all times, and in fact, he did leave for decades after these were stated. So I don't think the Miranda framework is the appropriate one here. Additionally, it's important to note that he was represented by counsel throughout, and that is really what Miranda is. Miranda is designed to protect from police infringement on a person's ability to protect against coercion, and that's what the attorney's entire job is.
Yeah.
When I look at the Basama factors that have been laid out, I don't think they
Sounds
apply
like
here
an
necessarily
ineffective
to
counsel.
establish involuntariness, really. If I apply that test, Mr. Davis passed with flying colors. I mean, this is a situation where he's an adult. He's not inexperienced in the criminal justice system. He has counsel present, he's expressly advised he is not under arrest. He's not inexperienced, he's not uneducated, he's not isolated, he's not subject to prolonged detention, deprivation, or coercive texting. He's invited to the situation. He comes to tell his story to avoid the federal government's issue. So I don't find it that it's involuntary either. However, I do have problems with that 2008 interview, but I don't think they were necessarily addressed in the framework that I'm given here. So I'm not necessarily saying it's admissible. I'm saying it's not voluntary at this time. So the motion is denied as written. So I'm going to order on that.
Thank you, Judge. Your Honor, just as a matter of clarification of the court order, is this one of those things where we can redress this?
We can address it. I don't know what basis fits better, but it's not involuntary in this framework.
That's fine, Your Honor, and I do understand the court's ruling with regard to that. I'm just trying to figure out in terms of timing whether or not we will have the ability to redress it.
I don't really have a ton of guidance on what I'm saying. I'm just saying that the framework that you presented me with, it doesn't fit as an involuntary statement. But you are free to redress it as you see fit under the legal guidance. Gang evidence.
Your Honor, this is the state's motion. Looking at the defense response and talking to Mr. Sams, I think we largely agree that it's admissible for the purposes of motive. So there's no question. They took some issue with the purpose of identification, but we're not doing it as a modus operandi. It's more identification as Davis's role within the larger South Central, for instance, why he was the person in leadership in order to issue those commands, why he had the ability to do that. That's what we were looking for in terms of identification.
Okay. Ultimately, gang information is gang affiliation evidence is a bad act, and there's generally some sort of bad acts, Petrocelli type hearing, although it doesn't really take all the traditional contours of Petrocelli hearing. But it seems as though Mr. Sand is not requesting that. He's conceding that it could be necessary for, or that he concedes the evidence of the affiliation with the Southside Compton Crips, personal leadership role within that organization, the rivalry with Montpero and the Lakewood Mall and the MGM Grand incidents are probative of motive. And so it seems like we've passed the point where I thought we would need an evidentiary hearing. Would you agree with that?
I agree with that.
On the clear and convincing of the gang evidence.
Yes, Your Honor.
So what it then leaves out essentially is the state is not seeking for identity, and so it's really just for motive. And so we're at essentially is this is a situation where you're seeking for any gang enhancement phase to be bifurcated from the guilt phase.
I think that's an agreement that we would have with the state with regard to that particular issue. The danger is the use of the word shock collar and then the use of the word green light. That's really where we're trying to get at.
Okay, so for you, your concern is those two terms.
Correct. I mean, those are terms that are associated with gang activity, and it's not just gang activity, but it's also associated with this idea of rank within the gang activity. Whether or not Mr. Davis was part of the Southside Crips, I think it's documented. He lives on the street in Burris, in Compton, and it's laid out. I think the fact that will be very clear about the fact that you move into a neighborhood and you're on the street, you become associated with that particular thing. I have a concern about the idea that now they're going to try to shoehorn in this idea that he's a shock collar just by the fact of just using the words and saying he was a shock collar.
What about his own words? What is the shock collar?
Once again, I think if the evidence comes out that way, I think that's one thing. But at this particular point, I don't believe that they have enough to at least say, hey, we can just throw it out there and make this a thing, like in their openings or anything like that. I think during the course of the trial, if that becomes evidence, that's one thing.
Shock collar and green light, go.
Yes, Your Honor. So by the court's ruling, the fact of green light is already coming in because it's specifically pulled from Mr. Davis's own words from his book. So, I mean, green light's already coming in. We have a good faith basis that it's coming in based on the court's ruling today. With regards to the shock collar, I mean, that is a term of art within gang hierarchy. The person who actually has the ability to direct orders to other people. And by the way, again, using Mr. Davis's own words from his book, he was the general. He was the president. He was the person that had the authority to make this happen. These are his own words. And so Detective Ladd, when he comes here, him saying that, yes, he was the shock collar, he was the person in that hierarchy that could order that retaliation is wholly appropriate given the context of gangs. Now, if the court wants me, I really don't know I'm trying to work out what's the way to deal with that, other than to just say, we know Detective Ladd testified to that based on his experience. It's in the grand jury transcripts. I mean, that's where he derived, that's where this term is derived from. So, I mean, he describes himself in this manner.
And maybe what we do in the meantime, Your Honor, is we set this for a very short Petrocelli hearing right before Detective Ladd takes a stand. And we can make that determination at that particular point with regards to that issue, very narrowly construed just on the issue of the shock collar.
I think we can, okay, so the motion to admit gang evidence, it seems like it's largely unopposed, and so it's granted the state can use it for motive, to establish motive. Regarding the issue, the gang phase will be bifurcated. regarding the issue of shot color and green light is within sort of the key sentence that
Yes.
is used, that Mr. Davis uses to describe the murder, the crime that he's charged with. So I don't think that can be excised from the case. It just doesn't make sense. The shot color, we can do that brief evidentiary hearing, and we'll hold out until the detective testifies in using that particular phrase. All right, State Brigade Order. Anything further?
Just a little bit. I expect the Detective Mon's officer's report will be sent over by the end of the week to Mr. Samms. And I know it's a short week, so I really mean by Thursday. There were a few other items. When I went through them, I didn't see anything. There was a couple transcripts of a couple audios that came through, and there was 2 audios. I think they're of random tips that came in to either Metro or LAPD. And so there'll be one last group of discovery sent over to Mr. Samms by the end of the week.
Okay. So it seems like discovery is ongoing.
Yes. The only thing we still haven't received is the lab, but I expect that the lab notes, I think because they're so old, there's literally testing done in 1996, that I think there was some search that had to be done to find it. We'll get them the underlying lab notes as well.
Yeah, there was a couple of things I think was mentioned in the last hearing with regards to discovery, conversations with Compton PD with regards to multiple other police reports that have not been disclosed. Are you talking about the same thing? Are those going to be disclosed as well? Other police reports in the last year. Oh, sorry.
Oh, maybe, you're right, maybe I sent it after that hearing. There was a day or 2 later that I completed all of the review of the Biggie Smalls murder file and sent over everything from that, as well as everything we have from the federal government 302s, the DEA 302s related to the drug transactions that we already discussed here in court today, as well as what we could find on confidential informants and any benefit they received in those prior investigations.
Thank you. And then just one final thing, Your Honor, with regards to transcripts, do we get a transcript of the hearing today?
Sure. Do you want to do a final status check trial readiness July 14th, or
We'll be here anyway.
leave it for calendar call?
I mean, we will be in here anyway, July 14th. I think we have a
Oh,
hearing
there was a
on
further
Mr.
motion
Sims.
eliminated, got set, so we can address anything else. Okay.
Okay.
All right.
Thank you.
Is that your motion eliminate or stays?
I guess it's Mr. Sims.
It's mine.
It's
Okay.
Mr. Sims.
All right, yes, you got your motion. Thanks,
Thank you,
guys.
Aaron.
We'll be in recess.
I bet this man right here did not think he was going to be 63 years old and still talking about Biggie Smalls and Tupac Shakur. Dude, all you had to do was keep your mouth shut. So, Debbie, you're asking, would that be prejudice? I am not sure what you're referring to right now. I'm going to play this. Oh, there we see old Keffe D's face.
Come on, guys.
That's how I walk when I have to stand for a long time. I walk like a Neanderthal. Wow. Well, I can tell you they have a final calendar date based on what my docket shows for August 4th. That will likely be the last date they have because it is set for trial August 10th. I'm not sure, Debbie, would that be prejudice? Exactly what you were referencing. Happy to visit that. So I have a very interesting take on this whole Tupac Shakur thing. I have rabbit holed some stuff in the past. By letting the jury hear he was a shot caller. I mean, I don't think so. If that's what he has referred to himself as and everybody else was referring to him, I would think that's more probative than prejudicial. And so I would think it'd come in. I think the concern is how anyone knows about that phrase and that he is connected to it. I think that's why they're why the judge is wanting to do an evidentiary hearing. That's my take on it anyway. So let's talk about Tupac for a minute here, because he's this gangster guy and everything, and I have done some research in the past, and I have seen video of Tupac at a very young age, and you all know I'm a theater geek. I know what sweet little souls some of my theater geek men friends or male friends are like. And there is not a whole lot of question in my mind that Tupac was gay. Now, maybe he was also bisexual. This is just me and my opinion. I am not accusing anyone of anything. Based on his behavior, he was a young, very artsy kind of guy. Taking too much NyQuil, little drummer boy. Little drummer boy thinks I said that I did reefer in the past. Research. Don't kill me. Anyway, back to my Tupac. I think he was a very young, artsy kind of guy, and I do think he was homosexual. Now, whether that turned into him being bisexual, I don't know. Maybe he always remained homosexual. I don't know. But I don't think this whole I'm a gangster and I'm a bad booty and all of that, I think that is all, I don't want to say made up. I think that he was involved with gang members. Absolutely. But I don't think that's who he really was. I think that there was a significant effort made to dirty him up, for lack of a better term, so that he would be more appealing to a specific audience. And if he remained the way that he came across while he was going to his liberal arts high school, y'all are probably old enough. You remember the TV show Fame? That was a liberal arts school. It was a school for the arts. That's what Tupac Shakur went to. That's the kind of school he went to. He wasn't in the city. He wasn't gang banging with anyone. He wasn't doing any of that stuff. He was at a school for the arts. That's where he went to high school. Camper for life, new info coming from Misdemeanor. You just never know what I'm going to pop off on. But I'm telling you, there are video clips of him being interviewed, and he is just this sweet, soft-spoken. All I can think of is gay theater geek that I would hang out with and have a ball with and love and adore and take under my wing and protect. And all the weird gang symbol things with the fingers and all of that. Yeah, I can't do any of that yet. But that all came later. And sadly, I believe it was because of all of his affiliations and the fact that he was so incredibly talented. That's why he lost his life. And I think, there might have been a girl involved. And I don't think that, yes, he was very effeminate, very, very effeminate. I don't think the girl that was involved in all this was even a girlfriend of his. I think it was just a friend, a really, really good friend of his. Let me see if I can find. Give me one moment since I have rabbit holed this before. Oh, here we go. Would you like me to play it? Would y'all like to see the video that has me absolutely believing this would have been, I got to get the right one here, so bear with me. All righty. Are y'all ready for this? I'm probably about to blow your mind. And maybe some of you have already seen this, but look at that sweet face. Good night, KS Granny. Thanks for coming in. All right. We ready? Because I still got a lot to cover. It's a Saturday night. It's going to be a long live stream.
Anytime. Okay, my name is Tupac Shakur, and I attend Tamalpais High School, and I'm 17 years old.
Okay. Do you like being 17?
And it's like 17 is such a weird age. It's such a in the middle age. You're not 18 yet, and you're older than 16. So. But I like it. It's nice. It's like a learning stage for me.
Do you wish you could be 18 and when you get some more rights?
Well, 18 will bring lots of responsibilities that I don't want, but it'll bring respect that I feel like that's the only way I can get it. You know, I try to be as mature as I can be and demand it wherever I can get it. But 18 is like, you're an adult. You like today when I had to sign the release form, I felt so bad because I couldn't sign it myself. I had to go and get my mother's and all that. But 18 it's just society's way of saying that you're ready. But 17, like I think I'm ready now, as ready as I'm gonna be in this world. But so it's okay. I guess 17 is all right.
Do you think that you should be given more responsibilities, or that you have much more value than adults place on you because of your age?
Well, the way that my mother brought me up is no lies, no, total truth. Everything is real in society, everything. If something's going on wrong in the house, I know everything. So it was like I was given the responsibility before I wanted it. And so now I can't really differentiate what great responsibility is because I've had it for so long. So she taught me how to be ready for it. And so that's good. And I think it's good because I know that, and it's taught me that when you get out there, the responsibility is staggering. And I'm ready. I'm going to be a little more ready than someone who's grown up in Disney World, with Santa Claus is coming. And so, I think I'm growing up good, as in all sense of the word. I think I'm growing up and learning about responsibilities and everything.
What do you think is the hardest thing about being a kid or being your age?
The hardest thing about being my age is proving to society that I understand what's going on. Like not everybody, but frequently teenagers are stereotyped in being loud music loving, girl chasing, car wanting, not caring about the world, coke heads, drinking coke and smoking and being drug addicts. And I mean, in some ways we are. I mean, I chase girls and want the car and loud music, but I like to think of myself as really being socially aware, and not just socially aware as being trendy, being peace, not that. I really think that that teenagers, they got a lot of responsibilities and a lot of burdens because, in fact, we're given a horrible world. We're given the gift that we're getting when we got to take over. It's horrible. They left us. They're leaving this world in bad shape for us to fix up. So I think that we deserve a lot of respect because, in the 60s, they changed a lot, and those teenagers were given respect because they changed a lot and they did a lot. We're given no respect, and we have to do a lot. I mean, the world, no secret, but the world is bad shape. So we have to do a lot. We have to do a lot of good things. So I think we deserve a little bit more respect.
Okay, it is a 35-minute interview. You can find it by simply Googling Tupac Shakur high school video. And this will come up. And y'all tell me, I personally, for me, when I look at this video, it is like there is this bright light of an aura just literally, he can't hide it. And sometimes when that light is so bright, it burns out really quickly. And this person is a different person than what we ended up knowing at the end of his life. And I cannot reconcile in my head these two things. I just can't. This is not someone that sounds like they're talking gangster. This is not someone that sounds like they're talking like they're uneducated. He does not sound like a young man that does not have respect for authority. He does not sound like a young man who's had run-ins with the law. He does not sound like a young man who doesn't respect his mama. These are not things that go together. They just don't. And this brightness, it's so funny. There is a young man in the show that I'm doing, and I have come home and told Mr. Demeanor several times. I don't know how old he is, but he seems very, very young to me. But he has old soul vibes for me. And he will always come to me, "Hey, Miss Janet, how are you doing this evening?" And he very much is like how Tupac was, this kind of brightness when he walks into your space and you're like, oh, he's here. That's what I see here. So, all the gangster stuff and all that, I just have a really, really very difficult time getting on board with all of that, because that video right there shows me a completely different person. And so you all have a homework assignment now. Who knew Ms. D was going to be throwing down on Tupac? I didn't even ever listen to his music either. I just knew he was incredibly, incredibly talented. All righty, let me take us. Oh, y'all. It's time for the craziness of Karen Reed. Is everybody ready for the craziness of Karen Reed? Because we had a couple hearings. Let me break down. Oh, let me see. Where are we? I've got to get us in the right spot. I think this is the correct one. This one's short and sweet. Oh, wrong thing. I hate when I do that. All righty. Let's do this thing. Yeah, right? Yeah. Very interesting. Never seen him like that. I know. That's the whole thing, is I'm just like so different from the Tupac that we saw at the end of his life. Yes, little drummer boy, listen to Dear Mama Ms. D. That's your homework. All right, let's head to Massachusetts for the craziness of the Karen Reed everything.
At length, what are the parties asking me to do relative to the motion to compel?
Your Honor, as stated at sidebar, the parties have reached an agreement. We're asking you to table the current motion, for instance, interrogatories for a later date, we'll try to have that all resolved timely.
Okay, court will take no action. Thanks for coming down. We'll see you next week.
Thank you, Judge. Thank you, Your Honor. Court, all rise.
So that was that hearing. Can you imagine being an attorney and having to show up for that? Way to go, Judge Gilday. Slaying it again. Yes, camper for life. Yes, less jaded. I will say, can you imagine what he ended up walking into? I'm thinking of, even if 10% of what we know may have gone on with, oh my gosh. Y'all know who I'm talking about. He's locked up right now. All the oil. Oh my gosh, why can't I think of his name right now? Sean John. You all know who I'm talking about. Why can't I think of his name? Oh, this is awful. What is his name? Diddy, thank you. P. Diddy. Can you imagine that sweet, sweet, bright, shining light of a young man walking into any sort of environment that was even remotely like what we all have, I'm sure, imagined was the life of Puff Daddy, P. Diddy, Sean John, all of it? I mean, that would instantaneously take so much of your innocence away. And I have to believe there were things that happened like that. You're not in that particular, you're not in the entertainment industry and not see those things. When I was very, very young, I had signed on with a talent agency in the Detroit area. And I was given the opportunity to MC a local awards show that was, I was going to be co-MCing with another gentleman that was relatively well known in the area. And I was 18 at the time. So I was very, very young, very naive. I grew up in a very small agricultural town. I didn't know anything. And I show up at this event and I'm all ready to go and I'm going to go out on stage and my co-MC is nowhere to be found. And I went backstage and I'm asking some of the people that were in charge of the event and scheduling things and you know, making sure the caterers were there and everything. I'm like, where is this gentleman? They were like, oh, we haven't seen him. And all of a sudden I happened to come around the corner where they had like, you know, the food and stuff like that for people backstage. There's a name for it. It just escapes me right now because words are hard today. And there he was, and he's bent over a table, and he turns around and looks at me, and he has white all around his nose. And I'm like, oh, that's what's happening right now. Oh, that's why you weren't able to get on stage. You were back here doing drugs. Got it. And that was one of those moments at 18 years old that I was like, you know what? I don't think I want to be involved in this kind of environment. If it means those are the kinds of things I'm going to encounter on a regular basis, I'm good. And I started at that point. It wasn't too long after that. I started to backpedal some on any sort of career or pursuing anything like that, because it scared me to be in an environment around people doing things that I in no way wanted to have any part of. And so I know how naive I was at that age, and I see that in Tupac. So I can absolutely understand how he changed and why he changed. All righty. The next one up is, I have here the anti-slap.
Citizen of murder.
Sorry. This is the anti-slap hearing. I haven't seen any of this. It is, well, this says an hour and a half, but it's not an hour and a half. I think it's like an hour long, approximately. I am taking this from, I thought I got this from the Young Jerks. Let me make sure that I did. It is. This is from the Young Jerks. He's always so kind and says, absolutely, you can use my content. I don't mind. So I very much appreciate that. Yay, Kelly! Girl power! Thank you. Yes, we are going to head on now. Speaking of girl power, another powerful woman, Karen Reed. Let us get into the business of Karen Reed and one of the last hearings. So here we go. Oh, I thought we were. What happened?
Conspires
There we go.
conspiracy to defame the plaintiffs. Number two, what we think is crucial about Cardno's finding is that the court commented that the petitioners in that case were involved.
Yo, what up, jerks? I'm running a little late. Had some dog walks. Wasn't sure this was going to get streamed today. They said.
All right. Sorry about that. I'm going to get us to the right spot. I think this is where we need to be.
Directly engaged with federal agencies responsible for environmental protection and the like. What Mr. Keffe is now trying to do is convert whatever history he may have had, in his words, of exposing corruption or going after the police, and making that what he was doing here, when what he is alleged to have done here is not criticize the DA's office, criticize the police department, but very directly accuse private citizens of murder. So that is, I think, never having petitioned the government directly as the activists did in Cardno. So we see Cardno as standing for the important proposition here that anti-SLAPP protected activity has to be tethered in some way to an effort to directly seek redress from the government or indirectly seek redress from the government. Here, Mr. Carney has not argued in any way that his false accusations against our clients that they had committed murder was a message that he conveyed to the government, that he intended to be conveyed to the government, that he had any mechanism for reporting to the government, and on the one occasion where he actually was given an opportunity to directly petition the government on the issues, he declined by invoking his rights under the Fifth Amendment because he believed, rightly so, that responding to inquiries in connection with any sort of petition would expose himself to criminal culpability. So that's why we think Cardno is important here.
So is the relevance of his invocation of the Fifth that he did not avail himself of the opportunity?
Correct. I think one of the things that the court is going to be asked to consider is whether there are objective indicia, and this is from Blakesley, objective indicia of the plaintiff's intent to reach a governmental body in his petitioning activity. And one fact that I think is important here is that of all the activity he engaged in, all of which was, in our view, non-petitioning and not intended to reach the government, designed to reach the government, When he had an opportunity to petition the government, he declined to do so. We think that's an important objective indication that his intent was not to reach the government. In fact, his intent was to attack and defame private citizens.
So, Attorney General, what do you say to the relevance of the Fifth Amendment?
There is no relevance to the invocation of the Fifth Amendment because he's being sued for his statements that he made well outside of the courtroom. Those statements were petitioned. The suggestion that Mr. Carney did not intend for his message about Karen Reed's innocence and the plaintiff's guilt to reach the government is belied once again by the allegations of the amended complaint. They admit that Mr. Carney was responsible for the hundreds of people who showed up at the Dedham courthouse every day during that trial to protest. Who were they protesting? They were protesting the prosecution of Karen Reed. Who was prosecuting Karen Reed? The government. Mr. Carney is clearly the leader of the national Free Karen Reed movement. And what do the words Free Karen Reed mean? What are they significant?
Oh, I don't know that he's the head of the National Free Karen Reed movement anymore. I don't know if that's accurate. Little drummer boy, that part seems shady. When he used the Fifth in trial, they should be able to hold that against him. I personally don't think that anyone should ever have the, if you invoke your Fifth Amendment right, I don't think it should ever be held against you. Period. Shouldn't. Gotcha. Yeah, I agree with that. It shouldn't be able to be held against anyone, him or anyone else. Anti-slap motion cost him $300,000. I don't doubt that at all. I don't doubt it at all. That's why words matter. And you have to be careful. When you do something like this, like I'm doing right now, there's a lot of responsibility that comes with this. And I always say, yes, we have freedom of speech in the United States. We do not have freedom of consequences. There's a difference. I can say whatever I want to say, but that doesn't mean there will not be consequences to the words that I say. And those, I think that's where some people get a little confused.
Other than a demand, a petition that the government do something or stop doing something. That's what he did. Obviously, his words we reached the government. You have in the record, early on, in some of his Canton cover-up stories, a directive to his readers. Email Michael Morrissey at mmorrissey@state.ma.us. That's in one of the very first Canton cover-up articles. He says repeatedly that our presence protesting and doing standouts is intended to let the government know that we are watching and that we will not let an innocent person be railroaded. The anti-SLAPP statute doesn't extend just to speaking in court or petitioning the government directly, as in filing a police report. It extends, and I know Your Honor knows this, to statements that are reasonably likely to enlist public participation in an ongoing judicial case.
I also want to make it perfectly clear that even though I say that, I don't agree with probably 95% of the drivel that I see in social media in reference to Free Karen Reed and anti-Free Karen Reed and all of that craziness that's going on, the macchiato of things and all of that. I still don't believe that Jen McCabe, Matthew McCabe, Colin Albert, Brian Albert, Julie Albert, Brian Higgins, and Michael Proctor were honest in their testimony. And I believe there is more to the story that they have not come forward and said. So, while I can be against saying, all the nasty things, please do not misunderstand that to mean that I am therefore for the McCabes and the Alberts and all of that craziness. You can actually dislike what someone says and still agree with them. It's possible. I know it seems difficult in this environment, but you can. Like, I can ask Mike Crawford if I can use his Young Jerks hearing live stream. And I can also agree that Aiden Carney shouldn't be treated the way that he's being treated. And I can also believe that Auntie Deb is funny, but I can also like Nan Gallagher. All of those things can happen. It really can. In Misdemeanors Chickadee Coop, it happens. What happens outside of here? I got nothing. But people that have been kind and good to me will get kindness and goodness back from me. And those that don't will be put on ignore.
I would submit that Aiden Carney successfully enlisted the greatest degree of public participation in a judicial proceeding in the history of this Commonwealth.
So let's talk about whether Mr. Gardner was doing it on his own behalf or his reading.
Yes.
I suggest that the claims against him, can't show the claims against him are based solely on petitioning activity. And they point to Judge Krupp's finding of an intent to influence and pressure the witnesses, as well as to Judge Duane's finding that Mr. Carney's purpose was to interfere, obstruct, if you will. So, what do you say to that?
Those rulings are not helpful on this notion in the court's past because they turn, as you just mentioned, on the question of intent. And the anti-SLAPP law provides that the motive behind protected petitioning activity is not to be considered at the first stage of the analysis, which is where we are. That's been the law ever since the Office 1 versus Lopez case, if not before, back in 2001. And the witness intimidation charges relate to conduct that is only partly part of this case. The witness intimidation rulings by those two judges do not analyze whether Aiden Carney's statements meet the statutory definition of petitioning under the anti-SLAPP statute. Instead, all those decisions say is that there's probable cause to believe that he may have, on the right proof, committed certain crimes that turn on subjective intent, and that is not helpful in the current motion. The current motion looks at statements. The question is whether the statements for which he has been sued meet the statutory definition of petitioning under the anti-SLAPP statute, and the question of motive is not to be considered. And that, not to get off the topic of Your Honor's question, but the commercial motive that
We'll get to that.
Okay.
So Attorney Manning, how do the line Judge Duane and Judge Krupp's statements are relevant?
So, Your Honor, Judge Duane and Judge Krupp's findings that Mr. Carney's activity was outside the protection of the First Amendment because it was activity that was intended to intimidate witnesses and harass witnesses is important because it provides you with some insight as to how other judicial officers considered whether or not that type of conduct was constitutionally protected and therefore likely to be petitioning. In fact, what Mr. Carney has done and what Ms. Reed has done by conspiring with him is pursued an unlawful campaign of harassment and intimidation, and a tool that they used in connection with that campaign was defamation. And so this, I think, the findings of Judge Krupp and Judge Duane really just point to a truism. And that truism is, in the history of the United States, there has never been a case that we can find in which a court ruled that one citizen may publicly accuse another of murder outside of any reporting to government and be immune from civil liability for it. There is no case, Mr. Kyle has not cited any case. It would be a radical expansion of anti-SLAPP protections for.
I don't know that that's a good argument. There's never been a case, so therefore that's why this case has merit? What? Sir, I'm lost. What? You might need to dumb it down for the slow people like myself, because I don't understand this argument. Saying someone is a murderer is defamation, but it was okay for them to call Karen a murderer. Am I remembering correctly? What? I'm already lost.
This court to find that. And that is highlighted in Judge Krupp's conclusions that what Mr. Carney was doing with respect to these witnesses, and again, I think it's important to separate what we've alleged in the complaint, which has to do with conduct directed towards these witnesses, versus other conduct he may have been involved in, relating to the DA or the investigation or whatever it may have been. What we've alleged is a course of conduct directed at these witnesses. What Judge Krupp and Judge Duane analyzed was the conduct he directed at these witnesses, and they found that there was no constitutional protection for it, which is exactly what we are saying in this case, that there was no constitutional protection for his defamatory and harassing conduct. The defamation here being in service of an effort not to petition the government, but an effort to intimidate and browbeat these witnesses into changing their testimony. And we make a specific allegation in the complaint in that regard, where Mr. Carney says, this will all stop if you flip. He's not petitioning the government to get these witnesses to flip. He's petitioning the witnesses themselves, and he's encouraging others to intimidate them in order to create that outcome for this reason.
Hold it. I'm fairly certain I remember hearing about a text message that Matt McCabe sent about something to the effect of, if she keeps her mouth shut, this will go away. If not, it's going to be an episode. Am I the only one that remembers that? Because that sounds an awful lot like what you're trying to fetch here. The projection is mighty.
So, Attorney Potter, along that issue, it would appear that your position is that the anti-SLAPP statute and the cases interpreting it precludes someone who has been publicly accused of murder by Mr. Carter from prosecuting an action such as this.
I'm sorry, Your Honor, I don't understand the question.
I don't understand it either.
Well, put another way, how can publicly accusing someone of murder be petitioning activity?
Oh, easily. It depends on the context in which the statement is made. And I will have to say regretfully that the plaintiffs have broadly overstated the law about this. They say on page 20 of their brief that the law is clear that accusation of criminal conduct is only petitioning if made to the police or other law enforcement agency. That's on page 20 of their brief. There has literally never been a Massachusetts case that has said that. They cite 4 cases in support of that assertion, but none of them say that. And, of course, reports to the police are petitioning, but that doesn't mean that reports that, a statement that the police are investigating the wrong person, who the police should be investigating, are these plaintiffs, Brian Albert, Brian Higgins, Jennifer McCabe, Colin Albert. They should be investigating them. And the fact that they didn't even consider investigating them shows that this police department is corrupt. That's been Aidan Carney's thesis throughout this entire time. In a footnote in their brief, I note that the plaintiffs concede that generally raising awareness about police corruption is and can be protected petitioning activity, they say, but they draw this distinction. Accusing people of murder can't be petitioning. In this case, they are all part of the same ball of wax, because the reason that Aidan Carney believed that Trooper Proctor and the other investigators were corrupt was because they didn't even consider investigating the people at 34th Ferry on that night in question. Instead, they decided to protect, he said, a Boston police officer and other powerful people in Camden. The corruption is bound up inextricably with the allegation that plaintiffs were responsible for this murder and not Karen Reed. The North American Exposition Company case says that in deciding whether statements are petitioning, you must look at them in the context in which they were made. The context is extremely important. And to say in the abstract that you can never be petitioning to accuse somebody of murder ignores that line of cases. We must look at the context in which this all occurred. The pending judicial proceeding against Karen Reed, Mr. Carney's campaign to try to ensure that those charges would be dropped and that the plaintiffs would be charged instead. That is the context in which these statements were made. That is a context that contributes substantially to the finding that this was all petitioning.
Well, let's talk about context for a second, because many of Mr. Carney's actions would be interpreted as seeking to make the plaintiff's lives miserable. In fact, he says something where he said somewhere, I forget where I read it, that they'll never live a normal life.
Sir, there are a whole bunch of people that are going through divorces, or maybe they're not divorcing and they're staying married instead, that are making each other miserable. And I don't think there is civil liability for making someone's life miserable. Judge Gilday, I'm going to need you to get your head out of your butt. Soon, please, preferably. What are we doing? Because he wants to make their life miserable? That's a civil lawsuit? Okay. Got it.
The plaintiff cited Judge Salinger's decision in Clay Court versus Colton for the proposition that targeting private plaintiffs for punishment is not petitioning activity. What's your response to that?
The motive behind petitioning activity, once you establish that it constitutes petitioning activity, is irrelevant. And I would suggest, Your Honor, that it's helpful to look at these allegations on a count-by-count basis. That is what Bristol Asphalt instructs must be done. The defamation count.
You all did that in your submission.
Well, I would respectfully say we did it better than they did. But on the defamation count, Your Honor mentioned earlier that reviewing the complaint is the first step in deciding what a claim is based on. That entire claim is set up at paragraph 156 in repeatedly publishing false statements asserting or reasonably understood to be asserting that the plaintiffs were responsible for the murder of O'Keefe and the cover-up of their purported role in the murder. Carney published numerous defamatory statements. That is and then they list the harm and the fault and all sorts of other things that they say provide the foundation of the defamation claim. Absent from that is any allegation that he set out to make their lives miserable. Absent from that is any motive allegation, which isn't relevant in the anti-SLAPP context anyway. The statements that plaintiffs were responsible for the murder were part and parcel of his petitioning about the corruption of the case and everything else. That is what the defamation count is based on. And, we say all the counts are based solely on petitioning. But plainly, we say right there in paragraph 156 that that's the foundation of the defamation complaint. So anything else about notions of motives to make their lives miserable or that kind of conduct isn't relevant to that defamation, which is the central count in this case.
I do. I have several responses, if that's all right, Your Honor, in response to what Attorney Pyle was saying earlier. You asked him earlier, why would accusing a private citizen of murder be petitioning activity? And he said, oh, easily. And then he didn't cite a single case in which that has ever been found. That accusations against another citizen, not funneled to the government, not a police report, not a tip to the FBI, not using an intermediary to inform law enforcement that somebody has committed a crime, just speaking it, that another citizen has committed murder, falsely, as you have to presume in construing our complaint. He says easily that's petitioning activity, and yet nowhere in the history of the Republic, as far as we can tell, has any court ever concluded that. In fact, to the contrary, we cite cases where, as Attorney Pyle says, petitioning activity is found where citizens report criminal conduct to law enforcement. But in those same cases, and I would urge you to consider Bowman, which is a First Circuit Court of Appeals case, those same cases acknowledge that the reporting of criminal activity to law enforcement is petitioning activity, but then reporting of it to third parties is not. And in that case, the plaintiff was somebody who had been accused of sexual assault. The accuser had previously made a complaint to the FBI and another governmental agency. Subsequently, she informed people with whom that individual was doing business of the same complaints. And the First Circuit concluded that while the earlier reports to law enforcement may have been petitioning activity, the reports to third parties were not. And here's the kicker. The reports to the third parties were to staff of congressmen. And even there, the First Circuit held that that was not petitioning. And there are other cases that we cite in which wrongdoing is reported outside of governmental channels and not given petitioning protection.
I'm curious. Does anyone think that anyone in Sandra Birchmore's circle and friends or loved ones, gosh, do you think they went to the authorities and said, hey, we think that Matthew Farwell is a murderer? And then the authorities went, oh my gosh, we should do an investigation and find out if this is true or not. Is that the argument we're using right here? What? Exactly. Why would a guilty person beg the feds to get involved? They wouldn't. They absolutely wouldn't. It wasn't until the feds got involved with Sandra Birchmore's case that anything has happened. That's being handled on a federal level. That's not something being handled locally. So this entire argument, I have a lot of problems with. And trust me all, I think I made it clear earlier. If not, I think Aiden Carney is a very complicated person. I think there are a lot of layers to him as an individual. I think he is a difficult person to be close to and to be a friend to. And there's probably a lot in his past that would explain why that is the way it is. But that doesn't mean I think he should be having to deal with all this bovine scatology.
I want to talk about Attorney Pyle's comment about context, that it's important to consider context. They cite North American expositions for that principle. We cite it as well. The context that the court was considering in North American expositions wasn't the political climate. It wasn't the overall course of conduct. It wasn't, some atmospheric assessment of what was going on in the world. It was the context of the forum in which the statement was made. And there, the forum in which the statement was made was to the South Boston Community Foundation, which was created by the legislature, placed in the executive branch, and responsible for distributing public funds. And that was the context that North American expositions, which they cite, concluded was an appropriate forum in which petitioning activity occurs. Here, what they are encouraging you to do is say, Judge, consider the gestalt of what Mr. Carney was involved in. Consider that he was in, as a general matter, using his YouTube page and his for-profit entity to talk about issues. That's the context in which you should find that his accusations against private citizens of murder were petitioning. No, that's not what the cases say. The cases say, the North American expositions in particular says, that when considering context, it is the forum in which the statements are being made. And I think that that's a crucial distinction. I do want to...
You just said the forum he was making those statements. It was under journalistic privileges, if it was in one of his articles. And the other is on a YouTube channel to raise awareness about a local criminal case. That's the forum.
Say one other thing in response to Attorney Pyle.
Just one.
I can wait as well. I know you came out asking questions, and I don't know whether, Judge, at some point you want to whether we should make more expansive remarks, but I'm happy also if you have something that you'd like to key in on.
Go ahead, say what you want to say.
I wasn't quite, now I've lost my train of thought. Oh, I think it had to do with,
Oh, yes, Kelly, because we read what they wanted to get of Karen Reed's in her private medical records. So you are absolutely correct. Sadly, his private therapy records would 100% end up in court and all over the internet. He doesn't have a right to privacy because of this case. Exactly. And neither does she, apparently.
intent and motive. It is absolutely true that the court should not consider Mr. Carney's motive at this point. And yet, Mr. Carney, in his memorandum, spends pages and pages and pages telling you that he was motivated by a sense of justice, that he was motivated to shed a spotlight on this criminal justice proceeding, that his motive was to spur others to action. None of that matters. Even if true, it doesn't matter. What matters is what he did and whether there is objective indicia of his intent. So his self-professed motives here, and the same with Mrs. Reed, don't matter. What matters is whether the record, with respect to the statements he made to our clients, presents objective indicia as to whether what he was doing was intended to reach the government. And here, what we say is that the objective indicia, the fact that he never actually reached out to the government, the fact that he declined an opportunity to do so, the fact that he encouraged his audience to use coded language to defame the plaintiffs.
What? Did I miss something? What is he talking about? I'm going to let it play here, but I got to back this up. Just he declined an opportunity to speak with the government. Sir, what are you talking about? Does anybody, y'all give me a show of hands. Who believes that if Aiden Carney walked into the Canton PD and said, I'd like to report a murder, that he would have been taken seriously? You let me know in the chat. Number 1, if you think he would have been taken seriously. And number 9, if you think he would have been laughed out of the police department. Y'all just let me know. Is he seriously saying that he needed to report this to the authorities? They were the authorities. That was the whole problem, you dipwad. I feel like I'm in an alternate universe. Right. All 9s. Yeah. I agree, Kelly. But yes, please report it because it's so effective in your area. So what do you do when you don't have a voice with your own law enforcement and your own authorities? You go to the public because there's strength in numbers.
That he encouraged his audience to use coded language to defame the plaintiffs. Coded language, meaning language that by its very nature would obscure the government from knowing what he was doing. The fact that he engaged in private confrontations suggests that there is an objective indicia that he was not looking to reach the government. That's what matters, not his after-the-fact self-comparison to Oliver Wendell Holmes. What matters...
What? Oh my, this man has a massive hard-on for Aiden Carney. I did not think that until that statement right there. I was going to ask, I don't know anything about this coded language, and I feel like, I mean, maybe it's more recent, but because I've kind of dipped out on a lot of this stuff, I'm like, it is way too crazy for me. The coded language was a joke. The coded phrase was "Turtle Boy is right." I feel like I'm in high school. What is happening?
matters is the objective indicia in the record as to what he did.
So don't worry, we'll get to it. So let's talk a moment about public participation. When I read your filings, I just get the sense that there's a little bit of overreach. And it's supposed to go to any statement reasonably likely to encourage consideration or review of an issue, and the language goes on. But how does posting to social media or encouraging people to participate in a rolling rally at plaintiffs' homes, the type of public participation contemplated by the statute?
Does Judge Gilday not understand how society works? I mean, he's said some dumb stuff before. This is dumb. I seriously feel like I'm in an alternate universe. Hey, hold everything. Hold everything. Because we have reached it again. We're at Bizarro World. We're back at Bizarro World. I can't believe it. Here we are again. Kelly says the joke was they said we are talking in code. Okay, what's the code? Let's make one up. Hence the phrase. I love it. This is so stupid. And yes, camper for life. Camper for life. This judge hates social media. Yes, that is why I'm splashing his face on my YouTube channel again. Because he hates us. Hey, Judge Gilday, how are you? Told you I'd make sure to have you on again.
There have been a number of anti-SLAPP cases that have turned on use of social media to inform and mobilize other people. I had the very first one. It involved the plan to build a racetrack in the Plain Ridge Casino, and the Superior Court there held for the first time that posting on Facebook is protected by the anti-SLAPP statute. Posting on social media is the way today in which people connect with each other. Aidan Carney has done that to great success.
It's also a great place for public discourse. Maybe I seem to remember something about that our founding fathers wanted to make sure of.
Getting people involved in these issues. Indeed, posting on social media and posting on the internet generally.
Jerks, I'm just going to stop this for a second.
Oh, Lord.
Some questions in the chat about what this hearing's about. This is for Karen and Aiden. I should have probably titled it differently,
hang
but this
on.
was last minute for you. But I not answer to this. Doesn't it's happens.
Things that are clearly to point out is what
Very difficult for Aiden to win, but we'll see what happens here. Same with Karen.
I would point out is what led your affiants Rita Lombardi and Paul Cristofaro to do things that are clearly public petition. Going to
Rita Lombardi came up. Rita Lombardi came up. Really gotten any of these film Karen. People call it
going to the State House.
Sorry, y'all.
The suggestion has been made Mr. Carney never petitioned the government on his own, but they allege in their amended complaint that he was there protesting at the Devon Courthouse. He was also up at the State House protesting to get the Attorney General involved in all of this. He decided that his words, his direct police report from Aidan Carney to the Canton police wouldn't have done anything. He wasn't a witness to this murder. He reasonably determined that the facts would show that mobilizing thousands of people to protest against this unjust prosecution would be a way, potentially, to get the charges dismissed as he believed they should have been, by putting pressure on elected officials to do so.
And she was acquitted.
Encouraging people to participate in a rolling rally.
The rolling rally, Your Honor, is very much participation in and likely to lead to further public participation. That was a caravan of cars that started in a supermarket parking lot, went to various people's houses, didn't stay for too long, ended up with a protest in front of the Canton Police Department. That is I recognize that he's been indicted for that conduct, but nobody was. It was a peaceful protest in cars, and Mr. Carney is vigorously fighting, of course, the criminal prosecution for witness intimidation that arises out of that rolling rally. It was also heavily promoted online, such that people who weren't there could see, look, there's lots of other people who believe so strongly in this cause. They're going to go out on a sunny day and participate in a public event. That is also reasonably likely to enlist further public participation by others in this cause. So it is part and parcel of the petitioning activity in the case, and it meets the statutory definition. Also, he's been sued, once again, for statements accusing plaintiffs of murder, statements that were made in connection with the ongoing criminal case. There's not just one element of the anti-SLAPP definition we're relying on. We're also relying on the statements that, at least during the entire time of the Karen Reed prosecution, the statements were made in connection with a pending judicial proceeding and were intended to reach the government directly or indirectly.
Well, let me turn to a few questions relative to the Reed motions. First of all, whenever you start arguing, I don't need to have the party spending the time in 12B6 part. I mean, I can review the four corners of the complaint for.
Why does he always tell Karen Reed's attorneys how they can and cannot argue motions? Why? Why does he do that? I've never seen a judge do this before. We just watch how many different courtrooms, y'all? 4 different courtrooms? 4 different judges. All absolutely delightful. And now we got this dork.
The other complaint is whatever complaint I determined was the argument complaint, and I'll consider your written submissions. But we start with the plaintiffs. Would you not have responded to the issues raised in the June 23rd amended motion to dismiss, or requested from the court more time to do so?
Your Honor, we do respond to the June 23rd motion to dismiss. It's our position that the opposition that we filed following service of both the June 18th and the June 23rd motions to dismiss address all of the issues raised in both of them. We didn't feel that we needed more time to respond. In fact, we thought that the appropriate course.
But you take the position that I shouldn't consider amending the second motion.
Well, we do. I mean, we think it was a violation of the rules for them to serve it out of time without permission from the court. We think that it didn't comply with 9C. We think there are a whole host of reasons why the court shouldn't consider it. But if the court were to consider it, our opposition, which was served after we received service of both that and the June 18th motion, apply to both.
You took the time to have an affidavit submitted, which included a copy of the June 18th motion to dismiss.
Yes, we did do that. I mean, I'm not sure I understand the suggestion.
Why did you do that if you responded to the June 23rd?
Well, Your Honor, we thought it was important to bring to the court's attention what we consider to be Ms. Reed's gamesmanship with the rules of procedure. So she serves on us a motion.
That's why you did it. All right.
Yeah, that's why we did it.
So, Attorney Sullivan, apparently the original motion to dismiss that was served addressed the plaintiff's original complaint, not the first amended complaint. Is that correct?
The original motion addresses the complaint, which is extended by an amendment.
Hang on. It would appear, from what I saw, that, and I'm happy to give you, because I did compare and contrast of the original motion.
Yes, Your Honor.
And the second one. But what it appeared is that maybe someone responded to the wrong complaint. I don't know. But after the issue was brought to the attention, your attention, or whoever in your office, you unilaterally filed an amended motion on June 23rd. And Attorney McKay references 9A. I might have missed it in 9A, but I don't quite see how you get to do that.
Well, Your Honor, the June 23rd motion to dismiss simply corrects the caption. But Your Honor, if I may answer the question.
The rule doesn't allow it, does it?
Shut up!
Does Rule 9A allow me to send a motion And then a few days later, say, yeah, I changed my mind, here's another one.
Nothing was changed. We didn't change. No one changed their mind, Judge. What happened was there was an amended complaint which simply adds additional factual allegations. There's no new.
But why wouldn't you ask for permission? Why didn't you just do it?
Because we thought we could reasonably deal with counsel. That's why, Judge. And I don't think there's any prejudice to them by getting a complaint.
There's prejudice to the process, and I just don't know. It just seems to me this decision such as that, I don't know whether it's a showing of entitlement or arrogance. I don't know which.
It's neither, Judge. It's simply correcting a motion to dismiss a complaint that was subsequently amended that has absolutely no change substantively, no change in parties, counts, theories, or anything other than additional facts, which we address in reply. So it's a correction of the original motion. We reached out to counsel after they pointed it out to us. Asked them
They
if-
told you they weren't going to accept it.
Well,
So you decided, okay, I don't care what they say, we're just going to do it.
how are they prejudiced? We even offered them more time to respond. It's form over substance, Judge, with all due respect. The arguments are still presented. The theory that they're advancing is still addressed. There's no prejudice. There's no change. It says some number of paragraphs. And where it said Plymouth, it had said Barnstable because this is where the case originally originated. So while I understand the mechanics of the process under 9A, we really haven't violated anything. We've responded to the amended complaint, which is purely an extension of the original complaint. There's cases that hold for that position. It's not an inoperative, superseded complaint. It's an extension of what was initially filed, and we've addressed the arguments.
It was filed as of right. So that's the operative complaint. The amended complaint was filed as of right.
But it still extends what was initially pled in the initiation of this lawsuit, which is a theory that has not changed by virtue of an amendment. What happens in the amendment is some additional factual allegations are included.
So why didn't you respond? Why didn't you address those in your June 23rd? For example,
we addressed in the reply, Your Honor.
We're back in law
You could've done
school
it-
again,
you
guys.
could've done it in
The
the
professor is teaching
amended
us.
motion, couldn't you? Because the reply is not to argue stuff you might have missed. The reply is to talk about new stuff.
But we are under no obligation to address every single factual allegation.
But you're also under, you don't have the ability just to throw in a reply because you want to put in something you might have forgotten to address.
The purpose of a reply is to reply to the arguments that are in the opposition to the motion to dismiss, which is what we've done. And I'm here.
What is going on?
Comment for a moment about the reference to the statements that Ms. Reed made in 2024 to Mr. Muir.
Yes, sir.
And you addressed that in a reply. First of all, your reply uses the word allegedly in describing Ms. Reed's words. Do you not concede that she said those things?
Well, the alleged is behind what the purpose.
It says her alleged words. That's what your reply says.
Well, that's a
Your Honor, I haven't seen the documentary, so I am responding and advocating for my client's argument. So I'm not going to admit that that's what she said until I've seen it. So for the purposes of argument, I must have used the word allegedly. But the arguments are that that is petitioning activity.
Let's take a look at paragraph 33.
Oh, God, here we go again.
Yeah.
Oh, my God. This is literally, he wants to be a law professor.
Then
Please, Judge Gilday, just go find a college to teach law. Please. Because that's what you want to do so badly.
Paragraph 33 of the amended complaint, Your Honor.
yes. And that's where the plaintiff's alleged Ms. Reed was the source of a blog post. And where she says Jen McKay was the mastermind of the cover-up, that Paul Allen had motive to kill Mr. O'Keefe. And I use that particular paragraph just as an example. My broader question is, how are Ms. Reed's statements to Mr. Carney, not things in court filings, but her statements accusing plaintiffs of murder, petitioning activity? Or put another way, let's
Somebody else or others were.
That wasn't
That's
me.
in connection with that judicial proceeding. That's protected petitioning activity. The complaint rests solely on that type of language. It's also knowing that Mr. Kearney obviously has a wider audience is arguably to enlist participation. So at least 2 statements of the anti-SLAPP statute would cover those statements. From day one, she's taken the position it wasn't known. She was prosecuted twice and acquitted.
Yes, indeed.
For a moment, if you could, to just read statements to Mr. Muir.
Yes, sir.
She's suggesting you reply within the scope of the anti-SLAPP statute. One of the categories being encouraging consideration and review, reasonably likely to enlist participation. So, in the criminal trial, the case went to the jury on June 25th, 2024, correct?
No.
Yes.
Okay.
No.
3 days before, on June 22nd, 2024, Ms. Reed gave an interview to Mr. Muir, correct?
Correct.
Let's look at paragraphs 97, 98 of the amended complaint.
I've had people ask me why this case hasn't been discussed at CrimeCon.
In there, Ms. Reed states, among other things,
I can assure you all, one of the main reasons this particular case has never gotten any traction at CrimeCon is because it is so volatile. Everything about it is volatile. Everything. And even the fallout that is happening with all of the huge supporters after the fact, it's all volatile. It's all volatile. It's sad, really. It's beyond sad. But that's why it only can stay in its, I should say corrupt. It can only stay in its little dysfunctional world because nobody outside of that dysfunctional world wants to be part of the crazy.
I know Brian Higgins had a role in helping kill him, helped him get him in the snow, and helped frame it. And then Mr. Muir asked Ms. Reed, you make such strong statements about, I think, Colin Albert killed him. I don't know how without getting sued, because I don't even know if you're gonna. And Ms. Reed responds, if Colin can prove I'm lying, and this is defamatory, he can sue me. So my question is, how can statements by Ms. Reed outside of a criminal trial, 3 days before the case went to the jury, to your own words, a documentary filmmaker, that apparently were not going to be released to the public at that time, be considered petitioning activity?
I don't know what your statement says here. EDB, I'd argue, is huge and non-dysfunctional. Oh, EDB, I'd argue, is huge and non-dysfunctional. I got you. Yeah. Oh, yeah. I don't have any issues with EDB's chat and that. My only thing with EDB is that she makes it an absolute point that you cannot discuss any other content creator. And I have a problem with that because I think we're all a community and I understand that she's, you know, big and bad and all of that. And we all need to hear her roar and I'm good with that. But it goes a long way if we can all come together. It's not a competition. People are going to make their choices. It's okay. And if you're comfortable in what you're doing, you don't need to exclude other people. So that would be my only complaint with EDB is I just don't think that's necessary, but whatever.
Almost the claims and statements to the filmmaker petitioning activity appears to presume that Ms. Reed was either seeking to influence the jury or she knew there was going to be a hung jury. How could it possibly be petitioning activity?
What?
Well, firstly, the criminal trial is still ongoing. The jury hasn't got the case yet. The jury hasn't decided, so the judicial proceeding is still ongoing. And if we actually look at what happened, there was a mistrial, which leads to...
The intent for Mr. Muir to release those statements?
I'm sorry, Your Honor?
The intent was for Mr. Muir to release those statements prior to the jury?
Well, I don't know what the intent was with respect to when this documentary was going to be released.
Sure as hell wasn't going to be released in 3 days, was it?
Well, even if it's going to be released in the future, she ultimately is still in the process of being prosecuted. The trial hasn't ended. It's still under adjudication. It's still a proceeding. These are still statements. These are still protected petitioning speech, regardless of what Mr. Muir's intention was or when he was going to release this documentary. But ultimately, there's a mistrial, and she's tried again and has the same defense, and that leads to an actual acquittal. So this is also to enlist participation. This is also in connection with the judicial proceeding that's ongoing, and therefore falls squarely into the statute's definition.
If it's made 3 days during a pending criminal trial, made 3 days before the case is going to go to the jury, and how is it made to enlist public participation?
In the future, because there's, or at the time, it's still part of a judicial. If you take aside the public participation enlistment aspect of
Oh yeah, Kelly. These two are hosed. They are so screwed. So screwed. I am at this point, I'm at all of her attorneys are simply doing this and going through this process to continue to shed light on the crookedness. That's what I have to believe, because there is absolutely no way she's getting out of this. They will stack that deck and they will put their finger on the scale, thumb, hand, arm, whole body. There is absolutely no way that I can see any sort of fairness is going to come from this. The mind is made up. At this point, you know you're going to, I mean, she's going to have to pay them. I don't even know how much money. But let's at least get all of the evidence out in the public. Sadly, it also means that a bunch of her private information will have to be splashed everywhere as well. That's the price.
The statute. It's still in connection with the judicial proceeding. Whether or not the documentary was published that night, that morning, or 3 weeks from then, it's still in connection with the judicial proceeding. It's still petitioning activity. The statute doesn't say when the judicial proceeding has to have concluded by. It says in connection with the judicial proceeding. Taken to its logical conclusion, it might be that she's even been, hypothetically speaking, convicted, that she can still say those things and argue it's in the anti-SLAPP statute protection, because it's in connection.
And I'll guarantee you, if she was convicted, they wouldn't be pressing charges like they are. Wouldn't that be interesting to know? We all know the answer to that. They would absolutely not be moving forward.
The judicial proceeding.
So plaintiff want to respond?
Yes, Your Honor, I do.
Oh, Lord.
What Ms. Reed's counsel has just suggested is that there is no limit. There need be no nexus between what she says and the likelihood or the plausibility that it will reach a governmental body. He just said that even post-conviction, and we actually have allegations that she made defamatory statements, both she and Mr. Carney, post-verdict. But what they're saying is even post-verdict, because she in the past had been subject to a criminal prosecution, she is free to defame people, no matter the audience. Just because she's commenting on somebody else's guilt, not her own, somebody else's guilt. Blakesley says exactly the opposite. Blakesley says that this court is required to assess if a plausible nexus exists, and in doing that, analyze the objective indicia of a party's intent to influence a government proceeding, such as the timing, audience, and content of the statement. That's exactly what you were just trying to do here. With respect to the Murr allegations, the audience of Ms. Reed's statement to Ms. Murr is not the broader public. She's saying that in a closed private room to Ms. Murr and the small production staff around her. Now, if that statement is later published, She may be on the hook for additional damages, but the defamation that she articulates to Ms. Murr is not enlistation in anything. It is a private statement to Ms. Murr and her small production staff. And as you point out, I think, or Rob pointed out, the idea that there was a plausible nexus between that statement and something that was under review by a judicial body is so far-fetched as to be totally unreasonable. That statement wasn't going to reach any judicial body. By the way, Karen Reed, if she wanted to reach a judicial body, had every opportunity to do that. Instead, she's talking to a documentarian in private and accusing all of my plaintiffs of murder. Period. There is no nexus to any judicial proceeding. And this does get to the post-verdict statements that we allege she made and that Mr. Carney has made up until last month. I can touch on that now because the issue of having to analyze whether there's a plausible nexus is one that's going to apply equally to those statements. And what Ms. Reed has argued is that her statements in, I believe, 2026 to the Rotten Mango podcast, in which she again defames our client post-verdict, well, she argues.
Y'all let me know if voicing your opinion about individuals and their activity in something, do y'all think that's defamatory? If I think that my neighbor dumped garbage in my backyard and I go out and I tell everybody that I know that they're garbage dumpers because they dumped garbage in my yard. I believe they dumped garbage in they're garbage dumpers. Is that defamation? I'm legitimately wanting somebody. I would love to have this dialogue and this debate with someone because I genuinely want to know. I mean, I feel that way. There'd be no speech ever if it was, like Kelly says. I mean, if my opinion of someone is that they murdered someone, if my opinion of someone is that they are a pedo, am I defaming someone if that's my own personal opinion? So I'm allowed to have my personal opinion. I'm just not allowed to share my personal opinion. Is that what this is about? Every time he gets up to talk, I feel less sure and less certain of what exactly they're claiming is defamation. Every time.
That has a plausible nexus to the O'Keefe family's civil case against me, and that by accusing these innocent people of murder, perhaps I can convince the O'Keefe family to drop their case against me. Now, the O'Keefe family isn't a governmental body. They're a private litigant. That's not petitioning activity. And Mr. Carney equally has a lame excuse for his post-verdict statements, where he says, well, there's the statute of limitations for murder still exists. I can spout accusations of murder into the void, and there's some plausible, some governmental entity will pick that up and then prosecute these innocent people for murder. That is simply not plausible. It's not reasonable. It's an after-the-fact justification that has no support in any of the case law. Go ahead.
I will tell you this much. John O'Keefe did not die by someone taking a vehicle and running into him. John O'Keefe did not die at the hands of Karen Reed. No matter how many times they want to twist all of the facts, it didn't happen that way. So I'm going to need you, sir, instead of just screaming defamation, how about some proof? Proof that what she's saying isn't accurate and isn't true. Prove it. because it was a dog bite or dog injuries on his arm. You know, I saw the video clip. I don't know if y'all did earlier today. I think it was earlier today of dude that got in an altercation with his best friend on a dock and got shoved backward and gets hit in the back of the head. And the friend dumps him off into the water. I assume that he died. But the way his head at the back cracked into that, there was a like a corner, an edge. I was like, oh, that looks familiar.
Your Honor, the statements are still in connection with the judicial proceeding.
Okay. Attorney Kyle, I guess the characterization will excuse my warrant some response.
Thank you, Your Honor. And I'll note that the argument that was just made, that post-verdict statements can't be petitioning, was not connected to any element of the definition of petitioning in the anti-SLAPP statute. So I'll read one. Any statement reasonably likely would encourage consideration or review of an issue by an executive body. The Norfolk DA's office still exists. Karen Reed has been found not guilty. If Karen Reed's not guilty, somebody else is guilty. Aiden Carney fervently believes that the plaintiffs are guilty. It is still possible for them to be charged. In fact, one of the...
I swear it's like he was waiting for me to say what I said, because that's almost exactly what I just said.
Allegedly defamatory statements that they identified in this case is a TV interview that he did, not one of his YouTube videos, but a stand-up TV interview right after the verdict. And Aiden Carney said, "I would hope now that Karen Reed has been found not guilty, we can all unite and demand that the Alberts and the McCabe's be charged with the killing of John O'Keefe, because they're the ones who did it." That is a demand on the government to bring charges. It is a statement also that is reasonably likely to bring about further public participation to demand that charges now be brought against the real killers. That is petitioning.
Attorney Simpson, didn't give you the chance to argue your motions. What would you like to add?
Your Honor, what I'd like to add is, without regurgitating what we've already said about stage one of the Bristol Asphalt Framework, the sole crux of the complaint, the amended complaint, this lawsuit against my client, is solely based on statements that are petitioning activity protected and immunizing her under the anti-SLAPP statute. The second prong of the framework requires the burden to shift back to the plaintiffs to show that the statements are devoid of any factual support or any legal basis. We have put forward enough evidence. You referenced the affidavit and the transcripts attached to my declaration affidavit. That's in there, and they cited to in our brief. But the facts that established at stage two of the framework, most importantly, my client was acquitted of the prosecution's charge that she was responsible for John O'Keefe.
I love he keeps saying that.
The case of Faber versus Walton, the holding was judgment in favor of a party to litigation is conclusive evidence that petitioning activity was not devoid of any reasonable factual or arguable basis in the law. She submitted an affidavit that she did not strike Mr. O'Keefe with her vehicle.
What's the nexus between the finding of the Norfolk Superior Court in a criminal case against one defendant to claims against these plaintiffs?
Because her petitioning speech has to be...
Is he serious? What is the nexus? Judge Gilday, Your Honor, I don't know if you're aware, but a man named John O'Keefe lost his life. And so the nexus between these things is that he is no longer alive. And his body was found on the Alberts' front lawn. I don't know if you're aware of that or not, but that likely looks like a nexus to me. Just gonna throw it out there.
Supported by facts. They have to disprove that there are facts to support the petitioning speech. So that fact is highly relevant. She didn't strike Mr. O'Keefe with her vehicle. The chief medical examiner, Dr. Irini Scoibello, testified that Mr. O'Keefe's injuries were not consistent with a vehicle strike.
Sure
That they
were.
were consistent with a physical altercation. Mr. O'Keefe did not show signs of a physical altercation before Ms. Reed dropped him off at 34 Fairview Road in Canton. They did not have an altercation at the Albert's house. He suffered a wound on the back of his head, which was consistent with falling on a ridge surface. Present in the basement garage at 34 Fairview Road, Mr. O'Keefe had wounds on his arm, consistent with a dog bite. There was a German Shepherd in the home with a history of aggression. That's also testimony from the trial.
Let me break it all down for you, Judge Gilday, Your Honor.
Mr. O'Keefe's phone was at some point inside the Albert's home. That's testimony from Mr. Ian Whifford. Ms. McCabe used her phone at 2:27 a.m. on January 29th to type in how long it takes for a person to die in the cold. That's the testimony of Richard Green from the trial. In the early morning hours of January 29th, 2022, Mr. O'Keefe's body was not present where it was later found. That's the testimony of the plow driver, Lucky Lofford. And then there's the testimony from Dr. Laposada, the former chief medical examiner for Rhode Island, and a professor at Brown University, who opined that Mr. O'Keefe died from a massive skull fracture that was inconsistent with a vehicle strike. Those are the facts that the plaintiffs now have to prove are somehow devoid. We're devoid of proof. So the statements are petitioning. They are covered by the anti-SLAPP statute. The amended complaint rests solely on those statements. And the support for her petitioning activity is factually supported by what I've just read and what I've submitted to the court attached to my affidavit. For those reasons, Your Honor, for those reasons, I ask that the court dismiss the lawsuit against my client and award her attorney's fees as is provided under the anti-SLAPP statute.
Thank you, Mr. Simpson. Do you want to respond to Ms. Reed's arguments?
Just briefly, Your Honor. And before I do, I did just want to point out, in response to the court's question earlier to Attorney Pyle about whether posting to social media is, by its very nature, petitioning activity. We cite the Sheehan case in our brief, which stands for exactly the opposite. I hesitate, Your Honor, to even engage with what I just heard, because I think it's prejudicial to my clients to even entertain what I believe is just nonsensical recitation of evidence that doesn't implicate any of them in crimes that has been shown to be discredited. And I'll start by pointing out that he doesn't mention Colin Albert once. Doesn't mention him once. And the reason he doesn't mention him once is because he knows that the undisputed evidence that we present in our brief is that Colin Albert wasn't even there when Mr. O'Keefe arrived. And because he knows that the other evidence that they suggested implicated Colin Albert in some sort of altercation, that is that at some point he had scab knuckles, that they were in possession of photographs that show him before that and after Mr. O'Keefe's death with completely uninjured knuckles. So I only raise that to show just how frivolous these arguments are with respect to Ms. McCabe. Attorney Seligson just said again here in open court that Ms. McCabe Googled how long to dine cold at 2:27 a.m. That is not true. That was established to be definitively not true in the second trial.
No, it wasn't.
Ms. Reed did not allege it in the second trial. She didn't even call the discredited expert.
Oh, sir. This whole 227 thing, y'all, I believe this will be the 227 search is going to be the undoing of Jen McCabe. And the reason I say that is because we all know there has not been a single other case that we had to jump through the hoops that we had to jump through to get everyone to believe that this Google search didn't happen at the time it shows up on the Celebrite report, even though every single solitary other report, Celebrite report in the United States says it's at this time and this is what happened. All of a sudden, I apparently cell phones operate differently within the confines of Dedham County. I'm guessing that's what the issue is. They have their own little, it's like the Bermuda Triangle. They have their own little set of circumstances on how iPhones work or cell phones work. And the 227 search was not at 227. No, wasn't at 227. It was at like 637 or something like that. Only case in the history of time. This has never, ever, ever come up in any other case. When this whole theory finally gets blown to smithereens, and it will, it's only a matter of time. Because if what they're saying about Jen McCabe's phone is true, there are a crap ton of people behind bars that shouldn't be behind bars. This is a mess. Keep talking about 227. Yep, let's keep ratcheting it up.
Mr. Seligson just cited. To the contrary, Celebrite officials who managed that software testified without contest that that server showed up at 2:27 a.m. because a previously opened window was used to conduct the search at after 6 in the morning.
But nobody else's cell phone works that way, and nobody else's Celebrite data extraction looks that way, except for Jen McCabe's. She was the only one. She was the only one that had this very weird thing. Only one.
And that was a feature of the software and no evidence at all that the search happened at that time. And obviously, it's absurd to even suggest it because then there are two searches, I believe it's 623 and 624, that are miskeyed in exactly the same way as the prior search. It's just nonsense. And I think
sounds like a great cover-up to me.
Is, as you point out, the fact that a jury was not able to reach a verdict as to this, the fact that a jury concluded that there was not sufficient evidence beyond a reasonable doubt to convict Ms. Reed of these crimes is not affirmative evidence that anybody else committed them, much less witnesses who have never been targets, never been subjects, testified in open court multiple times. It's just offensive to hear that type of argument here. I don't think you're ever going to get to that stage of the analysis because I think, as we've shown, none of the allegations you've made against Ms. Reed or Mr. Carney in the petitioning activity have been shown. I'm sorry?
None of them?
None of them. I mean, I think there is...
It's not me. I don't know why it's doing that.
Mr. Carney, separately, now I'm not acknowledging that this was petitioning or not, but Mr. Carney has engaged in criticism of the Norfolk DA's office and police department and the police. None of that is at issue in this case. And yes, Your Honor, none of his accusations of our clients that they committed murder was petitioning activity. Not a single one. Not a single one. And there is no case to suggest that that sort of accusation against a private citizen, untethered to any effort to report to the government, is petitioning. None. And so the question I think that this case presents is whether or not this court is going to radically expand anti-SLAPP protections to include what historically has been considered defamation per se, and shut the courthouse doors to people like my clients who come here seeking and invoking the court's protection to press their claims, or whether they will have no civil recourse, not just them, but any resident of Massachusetts who is falsely accused of a crime by another citizen untethered to any petitioning activity, whether they will have civil remedies or not. And to me, the case law that we cite in our brief makes it clear that the narrow purpose for which the anti-SLAPP statute was enacted certainly does not extend to what historically has always been understood to be defamation per se, the worst type of defamation, the accusation of one citizen of another, a false accusation that they've committed a heinous crime of murder when that has not been tethered to any report, any petition, anything.
I don't know about that, sir. And nobody has proven to me that it didn't happen. I think that's a slippery slope.
Respect to government.
Thank you. Attorney Sullivan, anything else?
No, Your Honor, I stand by my
Attorney Pye.
Yes, Your Honor. The suggestion is repeatedly made that accusations of murder against private people are not protected by the anti-SLAPP law. That is not the law. And Mr. Maddy just said that those statements can't be protected by the quote, very narrow purposes for which the anti-SLAPP statute was enacted. The Supreme Judicial Court in the Duracraft case noted that the language of the anti-SLAPP statute is in fact very broad. It broadly protects petitioning activity, yes, even when it results in the dismissal of an otherwise meritorious defamation claim. It has long been the law, at least since McDonald versus Pate, which we cited in our brief, that anti-SLAPP applies to defamation claims. It doesn't matter if it's defamation per se, which is one of the old common law characterizations of defamation, the commission of a crime, loathsome disease, or whether it's defamation per quod. It applies to defamation cases. These plaintiffs' defamation claim is based solely on Mr. Carney's accusations that they committed murder, and those accusations were inextricably bound up in his protests against the prosecution of Karen Reed and the failure of the government to investigate the plaintiffs.
Anything.
The notion that there's no reasonable factual support for Mr. Carney's petitioning activity is.
Let's be honest, they didn't even properly investigate Karen Reed. Had they properly investigated Karen Reed, they never would have prosecuted her. So it goes back even worse than what he's stating. Not that they didn't investigate any of the plaintiffs in this particular case. They just didn't investigate. Period.
Laughable, given the extensive evidence that you've heard about at the trial and that our brief explains in great detail. Mr. Maddy didn't say anything about the Ford Edge that Lucky Laughlin saw parked in front of 34 Fairview. There's no explanation for that. The notion that he cannot make these statements, comment on a pending criminal case in order to get people involved in this matter is simply not accurate. The anti-SLAPP statute provides very broad protection for petitioning activity. And it doesn't require that anybody report anything to the government. It extends to the statements that are made that are intended indirectly or directly to reach the government. That concludes my argument on the anti-SLAPP motion. I did want to raise one other housekeeping matter with Your Honor in order so that the record can be clear. Back at the Rule 16 conference, Your Honor asked the plaintiffs to file a thumb drive containing all of the allegedly defamatory videos. We got it. You have received such a thumb drive? Oh, I didn't know that because I didn't receive a copy. I'm glad that that thumb drive is now in the record. I know there was a thumb drive attached to the anti-SLAPP motion that may have contained a few of the videos. I'm not sure if they
Right?
What?
I don't think we noted that we received it.
Oh, okay, all right. They sent it in. They sent a thumb drive in with the links and all that.
containing every allegedly defamatory video in the case? Okay, thank you, Your Honor. That satisfies me on the issue. I would request a copy.
Happy to give you a copy. Your Honor, very briefly in response. The Duracraft case cited by counsel.
Well, it's cited by everyone.
Which
I cited it too, so.
Which I relied on in saying that the purposes of the anti-SLAPP statute are narrow, reads as follows. Section 59H is, quote, strong medicine and used only in a limited context, requiring, quote, necessarily narrow and strict construction. That's what I was relying on when I made that observation to the court. And the last thing I'll say is, it is of course true that the anti-SLAPP statute applies to defamation. The point that we make, and I think the point that counsel doesn't even dispute, is that where the defamation involves accusation of a private citizen of murder, and that accusation is not made to a law enforcement agency or the government, that it has never been given petitioning protection.
Okay. Thank you all for your arguments. The matter will be.
So it would be protected if she told law enforcement? I'm pretty sure I remember her saying in the police department, it's on body cam. You know what really happened. Am I the only one? I think that was done. I think she did tell them repeatedly, I didn't do this. You need to look at someone else. I think something crazy went on in that house. So now because she decided to remain silent, they're now going to hold that against her. She was supposed to talk to the authorities and tell them, no, I'll talk to you. I didn't do it. These other people did it, and you need to investigate them. And then she would have been protected. Is that what this buffoon is saying?
Taken under advisement. Can I speak with all counsel at the side of the bench, please?
Oh boy, that's the end of that. Alrighty. I was going to go over the Mandy Matney ruling, but y'all are sick of me. We've been doing this for almost 5 hours. It's a Saturday night, so how about I save it for next Saturday? And I'll do probably next Saturday something similar. I'm thinking like Smorgasbord Saturday, because it'll be kind of a mishmash of a lot of different cases and what's going on in updates on them. And I will definitely cover Antonio Brown's hearing. I will cover Mandy Matney's, the decision from the judge about her 170 some $1,000 that she now has to pay. We're going to read it all though. It's 22 pages long, and there's just no way at almost 11 o'clock Central Time I've got it in me to do that one. So let me give you a few updates. I checked on Dr. Shaknovsky. No updates at this time. I don't see any new filings. There was a pre-trial hearing, I know, on Thursday of this week. He, as far as I know, I got to find it on my list. I thought I had a trial date for him. Let me go back to his case. The other one I checked on, of course, was Joseph Duggar while we were looking at things here. And there's nothing new really on that, except it does appear that Joseph Duggar's attorney has completed some depositions. So there's that. Let me take a peek here at Shaknovsky and see if there is a trial date. Let's see, court events. The last thing I show on here is a pretrial date of 7/23. Oh, I'm sure, Camper for Life, let me guess. He ruled in favor of the plaintiffs. Judge Gilday ruled on the anti-slap, and I'm just gonna take a wild guess. So I don't have anything new on Shaknovsky. I just see that depositions were completed in Joseph Duggar's case. And I have a few other things. I'm continuing to check on Buster Robbins. That is my Michigan case for Paige Renkowski. I'm not giving up on that one. And yes, Camper for Life. Yes, he ruled in favor of the plaintiffs. Shocker. So with all of that, my lovely people, if you were on Replay Crew, thank you so much. Thank you to my marvelous mod, Kelly. And also thank you to all of you who have stuck it out with an almost 5-hour live stream on a Saturday night with me. We'll be doing this for the next few weeks because of my schedule. So mark this as your new time over the next few weeks. And then we'll get back to our Wine and Crime Wednesdays and probably Monday Matters. So I'll be sending out the updated docket for the coming weeks tomorrow morning. And so make sure you check on that. I'll have as many updates as I can. I try to get them all, but sometimes I miss. I do my best. In the meantime, there's not much left to this day unless you're on the West Coast. So it doesn't cost a penny to be kind. So find someone to do something nice for today if you haven't already. And as always, remember,